But, item numbers 35 and 36, there are two writ petitions. My respected friends appear. In one writ petition, Mr. Das appears, the other one, Mr. Tiwari is appearing. I have been requested to appear on behalf of the government. The brief has been handed over just this morning. I'm praying for a little accommodation. We have all decided on a date of it. 2nd of September.
Okay. Just we'll fix it on second. We'll not record anything. Okay. On behalf of the learned advocate general has prayed for some accommodation today and seeks for an adjournment. Prayer is not opposed by the learned counsel for the petitioners. Accordingly, matter stands adjourned and be listed on 2nd of September 2024. 35 and 36.
35 and 36.
You know, I and Mr. Das, we are attacking each other by way of two writ petitions.
Okay.
As the counter blast to each other. In between, now Mr. AG has come.
That is more.
Now, whose side did you take?
Now everything will be resolved.
He's only laughing. He's not disclosing his mind. Mr. AG.
So, right.
May it please your lordship.
Yes.
Lordship, I beg to pray, my lord, I want to move two writ petitions today as unlisted, my lord, seeking your lordship's permission.
My lord,
Today.
in item number 29,
Item number
29,
49,
29,
29.
I have filed a objection petition to in the IA today. So I would like to mention,
For IA is for modification.
I was for the withdrawal and I have filed objection. Today.
Okay, item 29. You want to bring that on record?
Yes.
Yes.
I beg to mention item number 6.
Item number
6, small accommodation. Can it be taken up tomorrow?
why?
Mr. Tony Parthan is out of, he's on the way.
Not tomorrow.
Day after tomorrow,
We'll take it up on Monday.
Monday. Oh, bless.
Monday. On the prayer of learned counsel for the petition.
Yes, ma'am.
Yes.
I beg to mention item number 9, madam.
Item number
9, madam.
9.
Oh, from the concern of our side, my lord, may I pray this be listed after 2 weeks, madam?
2 weeks. Petitioner 2 weeks consent.
Obviously.
My lord, I beg to mention one unlisted matter, ma'am. Deeply.
My lord, I beg to mention item number 31 and 32.
Item number
31 and 32. Since the conducting council is out of session for some domestic issue.
31 and 32.
Yes.
When? 2 weeks.
After 3 weeks.
After 3 weeks. Petitioner 3 weeks.
My lord, I beg to mention item number 33, my lord. Supplementary.
33.
My lord, 33, my lord. My lord, this matter, can this be posted after 2 weeks, my lord? With the consent of the other party, my lord.
2 weeks.
And my lord, I beg to mention item number 13 and 14, my lord.
30.
13 and 14, my lord. Here, I have not yet received the para-wise comment, my lord.
13 and 14.
Yes, my lord.
Okay.
Can this be listed after 3 weeks, my lord?
Learned Standing Council for the Education Department.
Education Department. Yes,
Education Department submits that is 6. 13 and 14.
yes, my lord.
Yes.
I am for this, my lord.
Yeah, 13 and 14.
He says some adjournment is it.
My lord, after termination of my service, I am nowhere, my lord. They're seeking time for filing reply, my lord.
Okay. Learned Standing Council for the Education Department press for and is granted 3 weeks,
3 weeks, my lord.
to complete his instruction and file affidavit.
Deeply obliged. And my lord, I beg to mention at number 4 also, my lord. At number 4, my just now, recently I just got a pair-wise comment. I need to go through this, my lord.
Okay. You have
Not pair-wise comment, my lord. Affidavit in reply, they file.
have you taken?
Yes, my lord. Petitioners. Yeah.
Okay. Learned Standing Council for the Education Department to file it.
My lord, they have filed the rejoinder recently that need,
Submits that recently rejoinder, when rejoinder filed?
this week, my lord.
Okay, a rejoinder affidavit has been filed this week. Accordingly, the Learned Standing Council wants to have instruction
My lord.
from his client.
Yes.
Full stop. Accordingly, press for an adjournment. Prayer is allowed. List this matter after
My lord, 3 weeks.
3 weeks. 3 weeks.
Deeply obliged.
My lord, I beg to mention item number 22 and 23, man.
20.
22 and 23. Counsel for the petitioner is out of station and we have taken consent from the other party.
Out
And
of prayer of the Learned
Yes.
Council for the petitioner, matter stands adjourned and be listed after 3 weeks. Yes,
Your Lordship, may I mention item number 26 to 28?
item number
26 to 28,
26 to,
28.
yes,
We'll be filing a reply in IN number 10 2024, so may we be given 1 week's time to file the reply.
Learned Council for the petitioner. Press for and is granted 2 weeks time to file reply affidavit to the affidavit innovation filed by
Some individuals for impletement.
No, the Learned Council for the petitioner. Press for and is granted 2 weeks time to file objection in the IA. List accordingly. Yes.
Please, my lord. My lord, on 22/7, my lord, instructions were sought for from
So you
the,
file an affidavit, we
Yes,
issue a
really.
notice only, or you want to withdraw?
no, my lord, no, withdraw. In fact, as part of the last instructions were furnished, my lord.
No, we have seen that instruction, it's a marked as X. According to them, you are getting everything, there may be some anomalies.
And normally, my lord, and my case is that, my lord, my service conditions have been altered, my lord, without giving any opportunity. Now, I do not have any.
According to you, your service, okay, we'll examine this, that's all. What more? We'll issue a notice, otherwise it's a case for dismissal. At best the notice. You are Mr.
These okay.
Disoki, Learned Council for the petitioners, also heard this, L. Permit, Learned Standing Council appearing for the Agriculture Department. Full stop. The grievance of the petitioner is that his service condition has been altered by the respondent authorities. Full stop. Issue notice returnable after 6 weeks. As Mr. Suki has entered appearance for all the respondents. You are for all the respondents?
My lord.
All the respondents, no formal notice need be issued. However, extra copies, requisite in numbers be furnished within 4 days. Full stop.
Well, can it be,
Correspondence shall not be barred for the respondents to consider his representation.
just, my lord, can it be 4 weeks, my lord, instead of
4
3?
weeks.
Oh, lord.
Obvious.
Yes.
May your lordship.
Hmm.
Your lordship, this is a transparent posting matter.
Hmm.
Here, your lordship, the instant.
What is the wrong in this order?
Sorry, your lordship.
What is wrong in this order? Transparent.
Your lordship, here, your lordship, the petitioner has been transferred from her present posting place within a period of only 4 months. Whereas your lordship, the teacher's transfer and posting circular clearly says that a
Circular
minimum.
will not confer any right.
Yes, lordship.
Then
But your lordship, in the conditions of the appointment, there is also mentioned, clearly mentioned that within the period of 3 years, the petitioner cannot be transferred from his present posting place.
where is that?
That is in the,
Where is the appointment order?
yes, lordship.
Page 23.
Yes,
Huh?
page 23, yes, lordship. The order dated 28th February,
Ah,
Right,
page,
copy.
page 23.
yes. In page 26, Your Lordship, page 26. It is a type copy. And the condition number 7, on joining, the appointee shall have to serve a minimum period of 3 years at the place of posting.
Where?
Point number 7, Your Lordship. Page number 26.
You will have to serve 3 years.
Yes, Your Lordship, but Your Lordship, in the present posting
You
place.
will have to serve in the 3 years
Yes.
that you cannot resign from the service.
Yes, Your Lordship, but I have been
This is not
transferred from
saying
my,
that you will not be transferred.
yes.
They
That's
say
why,
it-
yes,
it is upon you, appointee shall have to serve.
yes,
It is a condition that your regularization is subject to you serving minimum 3 years.
yes,
Okay?
yes, Your Lordship. But here, Your Lordship, that's why I'm challenging the order, Your Lordship, passed by the
You
DDSC.
are not getting my point. It is a condition imposed upon you. It is not a condition to the employer that they cannot transfer you.
Yes,
It is a condition unto you that you cannot, you will have to continue serve minimum period of 3 years at the place of posting.
yes, Lordship.
So in the meantime, they can transfer you.
No,
Yes.
Your
My
Lordship,
lord, right, my lord is rightly pointed out, my lord, this page 23, my lord.
But we want to know why have you transferred her within four?
My lord, that is why, my lord, page 23, it's a regularization, my lord. Regulation order. And petitioner is at page 25, serial number 176, my lord.
Yes.
Now, it is not a, now this regulation has been done after regulation, matter. The posting has to be done by the DDSC at concerned district, my lord. At this, my lord would see 76 so and so Anjo, under the disposal of DDSC Anjo, my lord. This is the regulation has been done in this way, and this is the first posting, my lord, after regulation at page 32, my lord. Page 32, my lord, serial number 4, my lord. After regulation, you were serving as a contractual teacher, SSA, ISSC now. Now,
So it's a general transfer of
Yes, ma'am.
all these persons under this.
my lord. After regulation, this is the first posting transfer, my lord.
if I may, Your Lordship, I would like to guide you, Lordship, and para 7, Your Lordship, page number 9. Kindly see, Your
Para?
Lordship. Yes, para 7. Page number 9 of the writ petition, Your Lordship. Here, Your Lordship, we can see that this was the transfer order that was issued by the DDSC was issued on 4 July 2024. But again, after that, Your Lordship, the Director of Elementary Education circulate a crash WT message in which is clearly stated, if I may, Your Lordship, kindly.
Where is that annex 5?
Yeah, page number 35, Your Lordship.
Page
35.
25.
35. And 36 is the type copy. May I read, Your Lordship?
This was issued on 11th of July 24.
Yes, Your Lordship.
Then
The transfer order was of 4. And Your Lordship, why this WT message, crash message was circulated is because of the reason that is in the next page, Your Lordship, page number 37.
page number 37.
37, yes. I have annexed the part of the newspaper, Your Lordship. Here, Your Lordship, you can see that the reports of several politically motivated transfer and posting, especially targeting
Okay,
government.
when can you have the instruction?
My lord,
Friday?
my lord, can it be on Monday, my lord?
Monday till then status quo.
My lord,
Heard. We are not issuing a notice.
my lord.
We'll take it on Monday. Heard. Mr.
Kim Bang,
Your name is
Kaling Mibang.
Swen.
Yes.
The present writ petition is filed challenging an order of transfer dated 4/7/2024,
Yes.
whereby the petitioner was transferred from
Government High Secondary School, Hayuliang.
Government Higher Secondary School,
Hayuliang.
Hauliang, Hayuliang, Hauliang to the Gopt Upper Primary School, Dingliang,
Yes.
Onja District. Full stop. The ground of the ground of challenge of such transfer order is that the petitioner has been transferred within a period of 4 months from date of his regularization, in as much as his service condition do not permit any such transfer for next 3 years from the date of regularization. First of, it is his further case that such kind of transfer has already been banned by the competent authority in the education department. First of, considering the matter, this court would like to go through the exact reason and record of such order of transfer. Accordingly, let this matter be listed on Monday to give the date. Till then, status quo in respect of the transfer of the petitioner shall be maintained.
Deeply obliged.
Highly obliged, Your Honor.
Mayor, Lordship. Lordship, I'm appearing for commission, Your Lordship.
Now,
Your Lordship,
it's his third appeal now.
yes, Your Lordship.
It's now a third appeal. Tell us,
Basically,
where is your provision that 7 years old record cannot be given?
Your Lordship, commission has its own retention schedule, Your Lordship, wherein
Maybe, where is that?
that I have annexed, Your Lordship. in
Where
my
is that?
Petition,
Yes.
Your Lordship.
Yes,
Annexure 5, Your Lordship. Annexure 5, page number 24 to 28.
please,
Page number 24 to 28.
24 to 28. Okay, what it says?
Annexure 5, Your Lordship. Page number 24 to 28.
Why are you signing away to give it?
Your
Which
Lordship.
rule?
Your Lordship, page number relevant is page number 26, Your Lordship. Sorry, page number 27, Your Lordship. Annexure 1, wherein period of retention has been prescribed.
Page 26.
27, Your Lordship. Right side.
Then which page? I'm at page 27. Rule?
Page number 27, it says recruitment branch,
Recruitment batch.
Lordship. And next is page number 28. This is the relevant page, next page, Your Lordship. Continuation. Serial number 4. The information which R2 has sought, he has sought 4 numbers of information, Your Lordship.
So according to you, list of candidates selected, list of candidates is to be, can be retained up to 2 years.
Lordship.
And what was here,
Your
here is,
Lordship, in that case, Your Lordship, Lordship may come to his application, Your Lordship. That is in page number 13, Annexure 1.
now this rules is
These are
record retention schedule. This is issued under Article 320. Okay.
Lordship.
Now Annexure 1 is relatable to which rule?
Annexure 1 is applicants, respondent number 2's
No, no, no,
RT
no. That
application.
Appendix A. Appendix A that you have said is an appendix. Annexure A, page 27 is an Annexure A to the rule.
This
An-
is Your Lordship.
Annexure A is relatable to which rule? There must be some mention in the rule that it is detailed in Annexure 1. Where is that?
The rule is, Your Lordship, page.
Relevant rules relatable to Annexure 1. See, Annexure 1 is given. It's simply an annexure. There must be some rule in the body of the rules that it is described in schedule rule. Where is that rule?
Your Lordship, this is record retention schedule of Arunachal Pradesh State
Just
Public
a minute.
Service Commission, Your Lordship, page number 24. Then, Your Lordship,
Just a minute, just a minute. Is it a complete rule or it's a part of something?
It's an extracted copy of,
No, we want to see the rule.
then
See,
your lordship,
see, you have started rules 1, 2, then 2, A, B, C, D. Then there are certain procedure laid down. Suddenly, C commissions with, what is this tables we do not know. We understand particulars of record period of retention. This is a period is prescribed in appendix 1.
lordship.
There is a substantive part in the rule which must prescribe that records should be detained or wide out in terms of the period given in appendix 1.
Lordship,
Where is that?
lordship, then annexure 6, your lordship.
Annexure?
6, page number 29. These are the guidelines, your lordship, for relating, furnishing information relating to recruitment examinations by the commission, your lordship.
Hmm. No, that will come later on. Your whole case is that 7 years old record cannot
Yes,
be
that has
given.
been weeded out.
We want to know where is your power or where is your decision under the rule that these are the documents, it will be, this is the period we will keep, thereafter will destroy. We have seen from your rule that this is the procedure, but where is the substantive part where it prescribes that this is the appendix 1? Where is that? That is a vital thing.
This has been not,
Why should we believe annexure? Annexure 1 relatable what? What is the principal provision?
then your lordship, kindly turn to page number 29, your lordship, then.
Page 29.
29, your lordship.
Yes.
Serial number 3, this is the information sought by the respondent number 2, your lordship.
Page 29.
Page 29, serial number 3, your lordship.
Yes.
R2 has sought for mark statement subject wise plus viva voce. So may I read, your lordship? Serial number 3, it says without RTI, your lordship.
Hmm.
Without RTI, as per rule 46(1) of APPSC conduct of examination guidelines, candidates can get their marks.
No, that is without RTI.
Without RTI.
We are not concerned with
Then
without
through
RTI.
RTI, your lordship.
There is
Next.
RTI, through
Through
RTI.
RTI. Result of qualified candidates are already uploaded on website. Written marks and viva voce marks. So this is not required to be furnished under RTI. And next is serial number 2, subject-wise marks.
Hmm.
He has sought for subject-wise marks also, your lordship. Subject-wise marks of the candidates will be furnished to the candidate himself, herself under RTI after 6 months of recruitment examination, your lordship, and up to 1 year only. Beyond that, no information will be furnished on this. May see 3A clause 1 also for the furnishing of documents up to 6 months. So here R2 has sought
Now,
information.
what is
after
the
7 years.
prescription under the RTI Act?
Under the RTI Act, your lordship, under section 19 of clause 8, your lordship.
Hmm.
Although here, your lordship, power has been given,
Hmm.
but again, no way it says that public authority has to retain the records.
That's why your whole plank of argument. First issue is your reply is ground of rejection is that this is 7-year-old record.
Lordship.
So first point first, you will have to satisfy that we don't have any responsibility to keep this beyond 2 years. Therefore, we have destroyed, and we are not in a position to give.
There's no gazetted notification.
No, not we do not require any gazetted notification.
Only we have this retention.
You are not getting record retention schedule of Arunachal Pradesh Public Service Commission, Itanagar.
Yes, your lordship.
We want a complete, where is that schedule? Record retention schedule of Arunachal, which has been enacted in exercise of power under Article 320.
This is a rules for your lordship.
Huh?
Page number 25, it
Comes
says.
the rules of procedure, okay. Now, then if it is rules of procedure, Annexure 1 is a part of these rules. Kindly come to page 27.
Lordship.
Annexure 1 is part of the rules.
Lordship.
So we want to see the whole rules, where you are authorized the principal's rule which says that the period should be in terms of annexure 1.
That in that case, your lordship, I may be allowed to bring the guidelines.
Yes,
of
that is the
commission.
vital. We have already spent 7 minutes on the prayer of the learned council for the APSC methods and adjourn and be listed after. Two issues. One is, yes, you can have your own rules, but whether it is can be in derogation of the legislation enacted by parliament. And if two conflicting things are there, which will follow? This is one. Third is, then this is a third stage of appeal. Why should we exercise our writ jurisdiction, interfering with two competent appellate authorities? These three issues we'll have to answer. Of course, if your statement before the authority is that we are helpless in terms of this rule, after 2 years we have destroyed it. If you have kept it, why will not you give it? This is not your standard. We have destroyed. You say that 7 years will not give.
Lordship, that's what.
You will show us where is your provision that even if record is there after 2 years, you will not give. There are two things. One is power to retain and power to destroy. After 2 years, you can destroy it. Suppose you have not destroyed. Can you say we will not give?
No.
Then where is your stand that you have destroyed it? You have not said you have destroyed it. And we want disciplines because this is a very important act.
Commission
And we do
stands-
not want commission to take this kind of things. That's so itself shows malafide, smacks malice. Why are you worrying about giving these documents to it? Okay, you say that we don't have. Fine. We have, this is the procedure, we have destroyed it. Why are you shying away? You are an authority who is created by the constitution for proper public service, commission of all this.
Obliged.
Much appreciated.
Next when to be listed?
Next week, your lordship.
Next week.
Lordship.
Next week. Give a date. Next Thursday. Friday, don't give to. Huh?
Then can it be after?
14th. Keep it on 14th. Yes, next case.
My lord, I may be allowed to file rejoinder, man.
And council put a petitioner place for. You may file many things, but read court, what? Read court will decide.
Yes, my
Will
lord.
decide that don't change the route of the road. Huh?
No.
Can we say, no, he's forget about his father, think about this. No. Now somebody will come and say that, no, don't do change the route. This is not a case. After 3 weeks.
All right.
Yes, state.
Your lordship, here the state respondent is yet to file the affidavit.
Affidavit is required. Power department.
For
Whose
5, 6,
power?
I have filed, my lord.
You have power. What is your stand?
We are saying, my lord, that this is, here he is aligned to the lane, my lord. This lane is donated by other person, my lord. To us, my lord. To the extent we have placed some record, my lord.
According to him, you have acquired his land.
No, my lord.
And his house is midst of the, what is called powerhouse or something like that. Power department. Now, what is your stand? Yes, tell us. What is your case?
Your lordship, actually, I'm appearing on behalf of K. Law.
Oh, on behalf of.
Yes.
Yes, tell us. Now, what to be done?
Next date may be given. sir.
Adjournment.
Yes.
On the prayer of the learned council for the petitioner, Mitras stands adjourned and listed after 3 weeks.
I will.
From tomorrow, we will not come prepared with the files. Yes. Yes,
Yeah, Your Lordship, we have not received a parabase reply, so we need some more time, Your Lordship.
there is an interim order. None appears for the petitioner and call. Learned State Council prays for and is granted 3 weeks time to complete her instruction and file affidavit with first of interim order. Partial shall continue till the next date of listing.
Lordship, I on behalf of JG Lordship, as per instruction, in the instruction Lordship, case is in process Lordship.
Okay, Learned Council for the petitioner submit that this matter has become infructuous. Accordingly, the writ petition stands dismissed, being infructuous. You are Mr.
Mr. Jibam,
G. Bam.
on behalf of
Mr. G. Bam, Learned Council, appearing on behalf of
JG.
J. Zini. Learned Council for the petitioner. Submit. Yes, Mr. Das.
Yes, ma'am. It's a election petition
Hmm.
is in respect of a Gram Panchayat.
Hmm.
So I am agreed by the order passed by the election tribunal. That is why I have approved this honorable court by.
What is the order of?
My lord, I'll just tell your lordship, what's the point of determination? The point of determination, if we raise an objection before the returning officer.
Hmm.
Because the election was announced
Hmm.
by the authority in respect of contest of a Gram Panchayat.
Hmm.
I contested along with my learned friend contested.
Hmm.
Mr. Tiwari's friend contested. While filling up a nomination paper, we raise an objection before returning officer on the point that if you are voters in two constituency, you cannot contest the election.
Hmm.
That's the crust of the matter.
Now,
If you
what
contest-
happened thereafter?
I'll tell your lordship. Then it was rejected.
Hmm.
Then because he said that it is substantive, so it will be decided at the time before. So we contest the election. I lost. My learned friend has won. So now is 2025, it will be over.
Hmm.
Against that order, the losing candidate, me, we approached the tribunal,
Hmm.
election tribunal.
Hmm.
So there was evidence and ultimately the end result of the case is that no, if you are even your voter in two constituency, you can contest the election.
Hmm.
Because they said there are certain provision like 57 of the act of the Panchayat Act, which says that disqualification at what relevant time. So he discussed 108, 109. But greatest respect, the point here, what is not been discussed and what I have come before this court is 120 of the act. Whether my whole contention, point for determination is that to fill up of a candidate, to be chosen, my word is very important, to be chosen as a candidate,
Hmm.
whether this 108 and 109 has to be fulfilled on.
Now, what is the proposal today?
The proposition of the law today,
Is it for disposal?
this is
or
for disposal, man.
It is for
Disposal, because now 2025, I think 2-3 times the matter came up.
Hmm.
Because now 2025, the period will be over 5 years.
Hmm.
So it has come for disposal, these particular matters.
So he's enjoying.
He
Everybody is
yes,
ready?
he is ready.
I'm ready.
Yes,
Okay,
yes.
wait for some time. Let us finish. the
Yes,
list.
yes. I'm here for tomorrow also for one matter.
Okay.
Yes, that's why there is no, that's why we can do this matter. No, I just pointed at the proposition of
yes.
law. What is
Let us complete the list, then we'll come back.
Yes, yes.
And my lord, obviously, I will disagree with that proposition.
No, he will always disagree.
Lordship, some more time may be given to file affidavit.
Learned M.S.R. Basar, learned the State Council prays for further 2 weeks time to file the
Lordship.
petition of this. Prayer is allowed. List after 2 weeks on a date to be fixed by registry.
Obliged. My lordship,
Yes,
my lordship, we need some more time, my lordship, to file it.
you are MSG,
Yeah, Honorable.
okay, yeah, learned State Council, none appears for the petitioner and call. Learned State Council press for and is granted 3 weeks time, 4 weeks time to file affidavit. Yes.
Yes, my lord, I am for the petitioner, my lord. After filing of this writ petition, my lord, in fact, the basic challenge was the advertisement issued by the nearest authority, whereby the POSPO, this unreserved was eliminated. Now, since they have not conducted the interview, my lord, this petitioner has become almost infructuous.
So here was an challenge to an advertisement.
Yes, my lord,
Okay.
because
Then that has been cancelled.
cancel.
So
Yes, my lord.
new thing is to be challenged.
Yes.
Learned counsel for the petitioner. The present writ petition has been filed assailing an advertisement and assailing advertisement number 1/2022 dated 21/3/2022 issued by the nearest capital NERIST for filling up inter alia post of assistant professor in physics.
Not only that, my lord, there are so many posts.
That's why I say
Yes.
inter alia post of physics, full stop. Mr. Apang, learned senior counsel appearing for Nearest submits that during pendency of this case, the institution, that is Nearest, the institution within bracket Nearest cancel the advertisement number 1 of 2022 dated 24/5/2024. As the recruitment process could not be completed within the stipulated period of 6 months in terms of an office memorandum dated 11/1/2016 issued by Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, Government of India. Full stop. In view of such decision, nothing survives to be adjudicated in this writ petition as on date. Full stop. Accordingly, present writ petition stands closed, being infructuous. Needless to say that petitioner shall be at liberty to approach this court for any subsequent cause of action that may arise regarding this election.
Much obliged.
Full stop.
Much.
A copy of the communication addressed to Sri Apang, learned senior advocate by the Register of Nearest is kept on record and marked as document X. You need a copy or?
No, I have asked. Obligement.
Oh, my lord, here I'm appearing for the respondent and I filed an affidavit today, my lord.
18.
18, my lord.
You are who's respondent?
Sole respondent, my lord.
It is submitted by the learned counsel for the sole respondent that an affidavit in opposition is being filed or
Has been filed
has already filed
today.
today. Accordingly, matter stands adjourned. Same is not on record. Accordingly, the matter stands adjourned and be listed
After 2 weeks, lordship, for admission hearing.
after
2 weeks
2 weeks. Full stop.
for admission hearing.
In the meantime, the petitioner may respond to such affidavit in opposition. Full stop. List accordingly.
Oh, my lord.
Yes, what is this?
May I please, your lordship?
Yes.
Well, this matter related to date of a juvenile
when he was taken to observation home. When he was taken, well, in conflict, was killed on the way. So in this matter, we are seeking that the victim should be paid compensation.
What is the stand of the state?
State, they have filed affidavit, but then we have also made the SP, earlier SP party. As per the record, it shows that they have filed a wakalatnama.
That's why.
Yes,
So
my
who is representing that SP?
SP, I don't know, wakalatnama is on the record.
Because his affidavit also
Yes,
will be required.
required, yes, my lord. And respondent number.
Any name shown for respondent number 7? No, not name not shown. Okay, that's why we'll adjourn.
Okay.
Okay, name not shown in that cause list. Though office note dated 37/20/24 reflects that wakalatnama on behalf of respondent number 7 has been filed. However, because there is no reflection of name of such counsel representing respondent number 7 in the cause list. That being the position, registry to list this matter when? Next week?
Next week, my lord.
Let us see then, let me file then next week, Monday,
Yes.
Tuesday, reflecting the name of the lawyer, counsel of the respondent number 7 in the cause list.
Obliged. Hello, may I plead, my lord? 19 is contempt petition, my lord. My lord, operative person is, my lord, is in page 28.
70. Operative portion?
Is page 28, my lord.
28.
The solution, the direction was to pay the solutions, my lord. May I read? Page 20. In view of above, this rate petition dispose of with directions to the Deputy Commissioner Lower Debang to verify as to whether the petition herein were paid the compensation pursuant to notification such and such under section 10 of the such and such issued by Deputy the Commissioner Land Management, Arunachal Pradesh, whites such and such for acquisition of land starting from 5.6 on Mecca, only and any road bank of Ifipani River to 16 kilometer. If on verification merits, it is found that petitioner herein have been paid the compensation pursuant to the notification dated 29/7/2014 issued under section 10 of Balipra Tirap Sadhya Fronted Track Jum Land Regulation Act 1947. Petition shall also be paid the solution as well as the interest in terms of
Now,
Act of 2013.
Now, what, any verification done?
Basically, the Deputy Commissioner can only so far we have no information, my lord. The verification is directed and above the
file affidavit.
I'm appearing into for the respondent number 1, Deputy Commissioner. Today I'm appearing also.
You want to file it?
I'll be filing also.
You'll be filing?
Yes. Today I'm coming for the first time also.
Oh, first time. That's why I saw that this affidavit in Dusty only. I thought affidavit is fine. Learned
Only 1 week.
the learned counsel for the respondents, all the respondents.
On.
Respondent number 1, press for and is granted
1 week.
1 week time to file affidavit in opposition.
three and 2 and 3 we have taken step, my lord.
Dusty affidavit, contempt generally, contempt there is no scope of Dusty.
No, not Dusty. We have taken step.
Steps.
Yes, my lord.
What the office note says?
My lord, 2 respondent number 2 and 3.
Okay, let us see next week what we will do.
Okay.
On the others. Let us see. Let us in the meantime they may come also.
Obliged.
Yes.
My lord, this writ petition has been filed claiming for payment of solution, my lord.
Now, no affidavit filed.
Nobody has filed.
Yes, what is your stand?
My lord, affidavit perhaps may not require because the issue is pending before the Supreme Court, my lord, regarding the solution, because this land was acquired under 1947 regulation, my lord. So as per the act,
There are 2 problems. You should speed up or request for early hearing of the judgment.
My lord, yes.
Most of the cases will now be pending here. Because basically the provision was that Balipara and all kind of a by way of a notification in terms of a judgment, certain procedure and late and payments are to be paid. Suppose in a fine morning that your state's appeal is dismissed. In a fine morning, state appeal is dismissed.
Dismiss.
And all probabilities. Then who will pay all this interest? We will keep this pending. Think of it.
My lord, we have filed one intervention application.
In that,
Yes,
in Supreme Court.
yes, praying for early
This
disposal
is
of
in the interest of the state. You should fast track it. My lord. See, on an academic parlance, we are not on the judgment. That act itself is very clear. Constitutional provision is very clear that what will be applicable.
My lord.
Judgments have attained finality by constitution bench. What should be applicable?
Now, my lord, this is between the my lord, special act and the general act.
Yes.
Then, my lord, suppose if the Supreme Court helps, my lord, yes, under even this Jumeland Act also, 47, you are liable to pay solution. Then question come, my lord, who will pay that? Solution, that interest, my lord.
Who will pay? Those who have
Respondent.
acquired as per the provision?
Respondent. Respondent. Now, who are the
So
respondent?
therefore, I'm saying, ultimately, who will bear this interest?
My lord, that is the main problem. My lord, the
Interest will be borne by the taxpayers, sir.
my lord, Supreme
Or from the state executors by taking loan.
My lord, Supreme Court has already directed to deposit the solution amount before the Deputy Commission. And in case of Dibang Valley, that has already been deposited. But in case of Lower Sumansiri, it is not yet deposited.
You give that order, where is the direction?
Yes, I am having my.
Give us that.
You have to know that.
Give us that, bring on record, this I want. Because it was a situation where most of the land acquisition matter will get stalled. We cannot pass any order in any cases.
My lord,
It's an academic situation.
we are exactly aware of the order passed by the division bench of this court and the status of the SLP, my lord. We are also aware of that, status of the SLP. But then, my lord, the issue now, my lord, that it is not the payment, this is different. All the solution only, my lord. They have received the compensation matter without any protest. Compensation was.
That's why problem is this, they are saying we want to deposit. They want to deposit why? They are wise. That's why we say we want to deposit. Because they will say we have deposited. You have not released or whatsoever, pay interest. We are not liable to pay. They are wise enough, so they have deposited. They know very well that Balipara's days are gone. Those are gone days. Pre-Constitution Act, then this Act, Lara, 13 Act, it clearly says that yes, you have power to have existing law made applicable. You can have power to bring new land acquisition act. But you cannot do less beneficial, cannot be less beneficial. And procedure is to be followed. Procedure is to be followed under law. So think of the state government if this appeal is not decided for next 2-3 years. Advise your client. This is not a good decision. Advocate General is there, I'll tell him. Okay, on the, can I keep this?
Yes.
You also have instruction. Okay, we are fixing it after, when?
2 weeks.
After 2 weeks.
After 2 weeks.
As agreed to by the learned counsel for the parties, list this matter after 2 weeks. In the meantime, state respondent may file their affidavit if so advised.
My lord, in other cases where all the senior policies were appearing, it has been fixed on 2nd of September, madam.
2nd of
We are
September.
expecting AG to be here in this place on 2nd.
Okay.
So, yes, issue is there. No, that is issues, otherwise this is different, but then AG will be available here.
Okay.
on that day. So this matter can be fixed.
Okay,
on
second of September.
No problem, no. problem.
Mm.
Second
September.
September, all right.
Apply.
All of that.
Yes.
Lordship, here the respondent has to file the counter affidavit.
Yes. Retired.
Yes.
Then nothing survives. It's a transfer. Okay. The present writ petition is filed by the petitioner as alleging by being aggrieved. Present writ petition is filed by the petitioner being aggrieved by an decision of the respondent authorities whereby a representation submitted by the petitioner on 26/7/2023 was rejected.
Yes.
Full stop. Such representation was filed by the petitioner for his consideration of his case for transfer from one place of posting to another. Full stop. It is submitted by the learned state council that petitioner had in the meantime retired. Therefore, nothing survives to be adjudicated. Full stop. This court is also of the opinion that as the petitioner has retired in the meantime, the cause of action for transfer or consideration of representation for such purpose shall not survive. Full stop. Accordingly, the writ petition stands closed, being infructuous.
May please, your lordship.
Yeah. You want to file affidavit.
And
What
all-
about respondent number 4?
For also written answer as per the
You want to
office
take
note. I will take a press step.
Okay.
I don't know, hey, such a officer, how it was not, sir, superintending engineer. And it is written answer.
No,
Anyway,
it's
I will
not
take a-
answer.
Lordship, Anyway, I will
There
take
is
a
no
press
note.
step.
There is no note. You take a registered steps.
Yes.
In view of office note dated 8/4/2024, the learned counsel for the petitioner pressed for and is granted to take express steps for issuance of notice upon respondent number 4 through registered post with AD. Full stop. Such steps be taken within a period of 5 days from today. Full stop. List this matter after 6 weeks.
4 weeks.
4 weeks.
Yes.
4 weeks. In the meantime, the respondent may file their other respondents may file their affidavit.
All right.
Hmm. Which order? Okay. The present contempt none appears for the petitioner and call. Present contempt petition is filed alleging willful and deliberate violation of an order dated 16/6/2023, 16/6/2023, passed in WPC 485 of 2022. Full stop. Such decision was taken to appeal by the state of Arunachal Pradesh and Arunachal Pradesh in writ appeal 34/2023. Full stop. And the division bench by its judgment dated 26/7/2024 interfered with the decision dated interfered with the decision dated 16/6/2023 passed in WPC 485/2022. In view of the aforesaid, nothing survives in this contempt petition. Accordingly, same stands closed. A copy of the order passed in writ appeal 34/2023 produced by the learned counsel for the respondents is Mr. S. Tapin, learned counsel for representing the respondent number 123 is kept on record. Twenty-nine adjourned. Only deal with that. 29 adjourned already. Okay, okay, okay. Objection has come. Is it a record? Objection to the IA is a record. But whether it is tagged with, okay. The objection filed in the IA is not on record. Registry to take the same and list next week.
Lordship, last order, Lordship. This honorable court. Just upon.
Except remain this Mr. Dasan, example. Yes. Okay. You are for respondent number? Respondent number 4. Okay, Mr. Parme.
Lordship, the last occasion, Lordship, during the order of this honorable court, Lordship. Lordship, may kindly ferret the last order, Lordship. 23/7.
Yes.
Lordship. The instructions are sought from the governments. Lordship, whether how to affect the change of the date of birth of the private respondent, Lordship. This is clerically error, Lordship. This order petition. This is not petition, Lordship. This is private respondent. So how this date of birth is changed, Lordships? Yes, instruction.
So it should be respondent, isn't it?
Yes, yes, Lordship.
Now, when learned counsel submits that he has instruction to appear on behalf of respondent number 4, and he will take the 3 weeks time to file affidavit in opposition. And what about others? By this court's order dated 23/7/2024, Mr. N. Ratan, learned additional advocate general, was asked to obtain instruction from the respondent authorities as to the basis of effecting the change in date of birth of the respondent from the 14/12/1961 to 14/12/1966. The learned counsel for the respondent, learned counsel for the parties that there is an inadvertent mistake in the said order wherein the instruction was sought in respect of the petitioner, whether it ought to have been in respect of the respondent.
Yes, sir, private respondent.
Be that as it may. Any instruction received?
Yes, we have received on behalf of the respondent.
Instruction for respondent number 4.
Yes.
And what is it?
Respondent number 4, we have it from the respondent number 2.
Okay, what is the instruction?
Instruction because this was expanded. And this
in his instruction from the UD department where he has been enrolled.
Okay, Mr. Ratan submits that though he has received instruction as regards respondent number 4, is not it?
Yes, Lordship.
Respondent number 4 from his respondent number 2, that is the parent employer of the respondent number 4. However, such instructions shall be required from the respondent number 3, which department the petitioner has been respondent number 4
Yes.
has subsequently been absorbed, and therefore he seeks a week's time to obtain such instruction. Full stop. Accordingly, list this method after a week on a date to be fixed by registry. Full stop. You have been granted, prayer is allowed, 3 weeks time granted, we'll have the instruction on that day. If anything is to be passed, we'll see, or we'll go see.
They don't have the report, they have only the.
Let us see. Or can we say that you have received the instruction and file an affidavit? That also we can see.
Yes,
Huh?
Lordship. If affidavit is filed, also it's okay. Lordship.
Okay, has received the instruction. Received the instruction in terms of this court's order dated 23/7/2024, and he would like to file an affidavit in opposition. Full stop. Prayers allowed. Accordingly, list this matter after 3 weeks on a date to be fixed by registry. In the meantime, parties may exchange their pleadings.
Yes. Much up.
Matter is over. 34. Yes, Mr. Das, your case. 34. Okay, no, not 34. 34 is something different. Yes, what happened to this file? Barcode? Oh, no barcode here. No, you'll have to keep it because all these are important. There is a barcode item. Yes.
My lord, on the last date, Honorable Court directed friend to take instruction from department.
What instruction?
My verbal instruction is that they could not trace out that record. There is no record as such since the
This
first-
matter is listed in orders.
No, my lord, supplementary.
Orders. So if no record, we'll decide.
Actually,
File from the order of so and so, so and so. Now what to be done then? If no record is there, we'll have to give an.
actually, my lord, my service has been illegally discharged, terminated, discontinued. And the Honorable Court was of the view that was there any anything on the basis of which my service has been discontinued. And with that regard, my friend was.
Forget about it. If not, what is material available on record, we'll decide it.
Yes, my lord.
On 28th or thereafter? When?
Tomorrow.
Tomorrow, man, we have fixed some matter. Tomorrow division bench. This week not be possible. We have fixed many matters. Now suppose the upcoming matters is hard, then it will.
Let me dispose of today also.
Dispose of doing what?
Hearth.
No, you'll have to enter into the merit, whether it's right or not.
Yes. Actually, my lord, my service is discontinued without.
We understand. We understand.
Then after 15.
That's why you are fixing on 28, 20.
20.
Okay. 28.
Sure.
Mr. Das, 5 minutes break.
Yes, no problem.
Because you will at least take till 1, both of you.
I'm just whole day.
Or you
Whole
think
day and tomorrow, sir.
we'll not allow you to go it to tomorrow.
Yes, of course.
Or you want it to be
No.
travel to tomorrow.
Para 5, para 9, and para 10. Now, if you see,
Just a minute.
Yes.
Para
5,
5,
para 9, para 10,
para 9,
and para 10.
and para
10.
just a minute.
If you read para 5 at page 81, I think that will suffice. All are same.
5, 9, and 10. Which paragraph?
Para 5 at page 81.
Yes.
Your Lordship has marked. That with regard to statement made in para 5, it is stated a registration of one name in two constituencies will ipso facto not disqualify the person from voting or contesting an election. What is material is one cannot vote or contest from two different constituencies simultaneously. In the present case, it is not a case wherein the private respondent vote and contest from two constituencies. Fundamental rights of the respondent cannot be curtailed. Statements are not admitted. So this is the stand which they have taken. So now, once submission was been formulated or was argued before the returning officer, before the tribunal. Now, how it was dealt at page 82, kindly see para 9. Para 9 by the. With regard to statement made in para 9 of the election petition, your humble dependent begs to state, respondent number 4 fulfills the criteria as specified under section 120 of the Arunachal Pradesh Panchayat Raj Act 19. My lord will kindly mark this. 120 is our whole case. Now, your lordship will kindly mark it. That's our case. Pertaining to now, the returning officer says that he fulfills the criteria of 120 so and so to qualification of membership of so and so. Neither does it attract any of the clauses of section 57 pertaining to disqualifying members of Gram Panchayat and Chile as per section 12 subsection 2D4 of Arunachal Panchayat Raj rules, the returning officer shall not reject any nomination paper on the ground of any defect which is not of substantial character. This is of course, my lord, is a settled law that at that relevant time you cannot disqualify substantial. It is a settled law. So only what you can do and file an election time after declaration, which has been done in the instant case. That is no doubt about that proposition. What is troubling in this case is paragraph 9. He is, now kindly see, he is distinguishing 120, my lord will kindly see, respondent 4 fulfills the criteria specified under section 10120. That means what is saying, 120 of the act, he fulfills the condition.
Therefore,
so he fulfilled the condition, then 57 is only the ground of disqualification. The first sentence, I will just read that 57 to be chosen. So he fulfills under 120. So where is the question? Once he fulfills, then disqualification is other grounds. So you cannot bring that. That's his contention. I have to show that he doesn't fulfill. That's my argument will be made. So I am just showing what stand he has taken. Same stand he has taken in paragraph 10 at page 85. Same stand at para 85. That with regard to the statement made in para 10 at page 85, humbly begs to say rule 10 and 11 so and so and section 108, 17 pertains to preparation, revision, correction of which is prerogative of the concerned electoral and is beyond the purview of return. The claims and objection with regard to double enrollment, if any, should have been brought to the notice of electoral registration officer at the time of summary revision of Panchayat Raj electoral roll. Returning officer has no role in the preparation of the electoral roll. That's the stand. Now, if your lordship kindly see at page 90, that's a written statement by the winning candidate at page 90. Just note para 3, 4 and 5. Para 3, 4 and 5.
just a minute. WS respondent number
Is
4.
respondent number 4. That's a winning candidate. See para 3, my lord. Kindly mark 3, 4 and 5. Paragraph 3. 3, 4 and 5. If you see para 3, deponent is not the first time he is contesting for the Panchayat election. In the year 2003, he contested from so and so. The deponent contested as independent candidate from Ganga Panchayat for the post of Ansal Committee member of Ganga Panchayat, and we elected an Ansal Committee member. Now, if you see 4, deponent is and was very active in politics. Deponent or his family never casted their votes from any other constituency except from the one, that is 11 Bhat Ganga constituency. In the recently concluded Panchayat election, also dependent on his family casted their votes from 9-11 Bhat Ganga constituency. Only moreover in the year 2019, deponent was given the charge of campaign chairman of Ganga village polling station by the then contesting candidate and the present so and so. Since the deponent was born in Raya village, Toru circle, his name was enrolled as a voter in the electoral roll of the said constituency after attaining majority. Later, during 1990s, the deponent and his wife casted their vote in the then assembly election. However, neither dependent nor his family member casted their vote in any of the Panchayat election from 10 Toru Jilla Parishad. Now, Lordship will kindly skip the same thing. If you see at page 95, the sub-paragraph, 95,
Just a minute.
95, sub-paragraph, it is respectfully submitted, 95. They hear that the Arunachal Pradesh Panchayati Raj Act 19 was enacted prior to Panchayat election of 2003, where your deponent contestant elected from Ganga Panchayat. However, on that time, this allegation of being enrolled in 2 different constituencies was never alleged by anyone because his name was not enrolled in another constituency. That is reiterated. Deponent was born in so and so. He came to Itanagar in the year and thereafter so and so, because he said that earlier also his name appears in 2 different constituencies. It was never alleged. Nobody has complained. That's his whole stand. Now, my lord will kindly see at page 96, last few lines. 96. Moreover, your deponent recollect that he had requested the concerned authority to delete his name if already existed from the electoral of Toru Jilla Parishad in the year 2012-13. And your deponent was in belief and in good faith assumed his name was deleted as he has no connection with the politics of this constituency. So he made a prayer. He said, already I have made a prayer. But
At the end of the day, it is an admitted position that on
that
the
it is
date,
there. See, now that is been, if you see the cross-exam at page 1, now kindly see at 107 the issues framed. 107. 107 the issues framed.
Just a minute. Judgment started.
Judgment will start at page 168. But the issue which is, I'm sorry.
Issues at?
Issues at page 107. 107.
107. It starts at 107.
Issues has been framed.
No, the judgment starts.
Judgment starts at 168.
And then how can the issue?
No, the issues has been framed. Separate order issues have been framed. And you have to IS.
Okay.
Issues has been framed.
For order of framing issue.
Yes. Issues. My lord will kindly, that's why I have annexed that. 107. See that one, whether the suit is maintainable in the present form, whether the nomination paper of private respondent as a candidate for the post of Jilla Parishad member so and so is liable to be rejected for having enrollment his name into electoral roll of Jilla Parishad.
So this is the issue.
That's the main issue. That's
Now,
the whole,
how, where it is dealt?
now my lord,
Judgment.
I'll just show that one thing. Before your lordship goes to the judgment, see page 162, the addition affidavit in deposition of returning officer. Additional file. Now see cross at
162.
162. 160.
160.
Yes. 166. 162 it starts. The examination. And if you see the cross at page 166. 166 cross. Para 4.
Just a minute.
See para 4. In the complaint petition, the petitioner has enclosed the electoral roll Panchayat of 2017, in which the name of respondent for Taro Tagia was found in Toru's Jilla Parishad constituency and 11 Bhat Ganga Jilla Parishad constituency. I did not find update electoral in the complaints as dated by January 2020. So admitted position that his name appears in two electoral. That's a cross by the returning officer. Because we complained to a returning officer. When he crossed, it is admitted. Now, kindly see the judgment, how it was dealt by the learned tribunal.
In judgment at which page?
At 168. 68. Your Lordship knows the contention. I will not read the judgment. That's the whole summary of the, I told a proposition. How is the finding that has been dealt? If you see at page 175. See para 23, para 22, para 23. How he is dealing? Para 23. Now, my lord will kindly don't read it. It is 57. He quotes 57, 108 and 109. Lordship, right? I'll because I have to show that. Now kindly see at page 176. Now kindly see 176. Para 24. Section 121A of the Act stipulates that a person shall not be qualified to be chosen to fill a seat in the constituency of Gram Panchayat, Anchal Samiti or Jilla unless his, her or her name appears as an electoral in the e-roll of concerned concern. And clause C of subsection 1 of section 120 of the Act prohibits a person to be chosen to fill a seat in more than one Gram Panchayat, Anchal Samiti and Jilla Parishad. Further, by Rule 10(11), entering the e-roll for more than one Gram Panchayat so and so is prohibited. Now see 25. Now, para 25. The statutory obligation imposed upon the electoral registration as so and so is that when a voter is not found anymore residing in a particular Gram Panchayat so and so at relevant time, the authority concerned should delete the name of such voter from e-roll on application made to it by a person, including the voter himself or by his own motion. The Act of 1999 does not prescribe, now kindly see, for disqualification to contest election if name of a person appears in voter list, e-roll of two panchayat or the JP constituency. Reading all the provision quoted herein above together would go to show that the voter is limited to cast his or her vote from a single JP constituency. Legal consequences is that such a voter cannot contest an election to fill a seat of JP from more than one constituency. Corollary of this is that a person contesting election for particular JP constituency, he name must be entered in that constituency. In the case one hand, by implication of law, voter or a person having his her name entered in two voter list e-roll of two different JP constituencies is barred from contesting from both constituencies simultaneously. Now, if you see 27, cumulative effect of section 108, 110A and 120C Act is that a person ordinarily residing of a particular Jilla Parishad constituency has statutory right to get his or her name entered in the e-roll as voter and to be chosen to fill the seat of Jilla Parishad of that constituency. Now, quoting the judgment of the Supreme Court, certain judgment of Supreme Court has been quoted now. My lord will kindly see para 30. The preponderance of probability of evidence sufficiently shows that OP4 has discharged its statutory duty by filing application before the electoral registration officer of 10 Toru JP Constituency as far back as 2013. Electoral registration officer of so and so was under bounden duty authorized by a statute to delete name of OP4 from e-roll during summary or final revision of e-roll. The factual position of the case being so, name of OP4 finding place in e-roll of 10 Toru and 11 Bhat Ganga JP Constituency ipso facto does not fulfill requirement of disqualification enshrined in section 57 of the Act of 1997. In the view of the provision of so and so, having regard to principle laid down, mere finding name of e-roll for more than one JP will not entail disqualification. The case in an OP4 is not subject to this mentioned in section 57 of the Act. Facts and circumstances present case are different from the Chera Loma versus state election. As such, application ratio does not attract. Now, my lord, my lord, your lordship has gone through the judgment. Entire judgment, what I understand, is based on section 57. On 57. Now, there is one judgment which was shown by the High Court which decide this is a distinguishable, that judgment. I'll show that judgment. First, which is most important in this case, 57, 108, 109, and red with 120. That I am going to show, my lord. Kindly see, my lord, the Arunachal Pradesh Panchayat Raj Act 1997.
Yes.
Now, if you see 57, section 57. My lord, the opening sentence, if you see 57,
Starts
at page 15, 15. 15 at top 57, section 57. Page, we have marked here, no? Page 15.
Yes.
And if you see at page, section 57, the top. A person shall be disqualified for being chosen as and for being a member of Gram Panchayat, Anchal Samiti and Jilla Parishad. If now I'll pause for a moment. While I am pausing for a moment, please don't go further A, B, C, D. First, a person shall be disqualified for being chosen. Now, if you see now 120, my lord. See, please 120.
Of the
120 of the Act. The same book. At page 28.
120.
120, section 120, page 28. See 121. A person, lordship got it?
Yes.
Shall not be qualified to be chosen to fill a seat in a constitutional Gram Panchayat, so and so. So what it says, my lord? It says that if you have to qualify to be chosen to fill a seat, now these are the conditions has to be first fulfilled. Disqualification is later on. First, you have to be chosen.
Yes.
Now kindly see A. His or her name appears as an electoral in the electoral roll of a concerned constituency of a Gram Panchayat, Ansal Samiti and Jilla Parishad. Now if you see 2B, C, kindly see, a person shall not be qualified. Lordship got it? Just at page 29.
Just a minute. Give me a minute. 120. Now, this 57 is under which chapter?
It is under chapter 4.
Chapter 4. And
This is
under
chapter 6.
6 starts at page.
It starts at page 1. It start from section
25.
104. Yes, page 25. It starts from chapter 6, page 104. Superintendent's direction, control of election to Panchayat Based. Lordship got it?
Okay.
Now you see 120.
So chapter 6 deals with the procedure of elections. You will have to also answer to that.
No, I'll
Yes,
yes.
That's why I have specifically pointed out this question, because there will be a meaning to the chapter as
Yes.
such. The chapter deals with procedure of election,
Yes.
and chapter 57 is relates to page 54.
Page 15.
No,
Chapter is 2.
Page
That chapter
deals
for
with-
page 13.
This chapter 4 deals with
Ansal Samiti.
Ansal Samitis. Yes.
My lord, 57
Hmm.
has to be correlated with 120 because the procedure has been
No,
laid
that-
down.
that-
I'll show it how.
No, that
That's
is
why I
fine,
know,
that is
my lord, I
fine.
kept in mind. Your lordship may ask that these two are under different chapter. One
Different
is a
chapter
no,
dealing
no.
with different.
Why all this? No, not. Why the reflection, if your lordship kindly see 108, 109, all read with the rules. So all rules are connected with, is an act, the procedure has been laid down on the
No,
rules.
it's connected.
Yes.
We'll have to
So,
read
no.
the scheme of that. We'll have
It's
to understand.
total.
But there may question because in many judgments, it is when there is a disparity between two sections.
But-
Always the scepter where the specific rule is provided is being accepted.
It has
It's a
to be,
settled provision.
no, my will be.
No, we'll go to
50,
that. Just
57, 57 has to be harmoniously read with 120.
That's fine. That's fine.
That's so 120 kindly see. If you see a person shall not be qualified. Once again, my lord, at 28, a person shall not be qualified to be chosen to fill a seat in a constituency. So, my lord, number one,
yes,
to be chosen to fill a seat in a constituency, these are the qualification, either A, B or C. If you see C, a person shall not be qualified to be chosen to fill a seat in more than one constituency of a Gram Panchayat, Ansal Panchayat, Jila Parishad. So it is an admitted position that he is in respect of in two constituencies his name.
Can it be proposition like this?
Yes.
Had he been elected,
yes,
that could have been a ground for his disqualification for being chosen as a member of the Panchayat and member of the Panchayat, not for the purpose of election. Because he will have a chance to delete his name from the Panchayat. Okay. So can it be that therefore two provisions are given in two chapters? One is for that can be a ground for disqualification because a person can be disqualified after election also. And other parties for the purpose of election. For the election, because if you see the word to fill a seat.
Yes. In a constituency.
To fill a seat and to be chosen being a member.
Yes.
There may be a distinction.
No.
No, just
no,
this
that's
is
right. That's right. To be chosen to fill, you cannot read both the words separately.
Chosen to fill.
You cannot read.
This
My humble submission will be you cannot read both the words separately. One is chosen, one is to fill.
No.
You have to read
chosen to fill.
So that's why
So it's a filling up.
Filling up to be chosen. So to fill up, to be chosen in a particular constituency.
Fill a seat in a constituency.
Yes.
So it basically relates to the condition of election.
Now, my lord.
Yes.
If C kindly be seen, so that's my case.
Yes.
He
Now we'll go to which provision?
C, 120C. 120C, a person shall not be qualified to be chosen to fill a seat.
121C.
1C.
A person shall
Yes.
not be qualified to chosen to fill a seat in more than one constituency of a Gram Panchayat. Okay.
So, and his or her name appears as an electoral in a electoral of a concerned constituency of a Gram Panchayat so and so.
A person.
So he has.
You are reading C.
A also, C also.
C.
A
Of
also
the
he has to be valid.
as an electoral in the electoral constituency Gram Sabha.
So there has to be one electoral one. There is no question of validity. Valid means one. There cannot be in two constituencies. Now, if you see, please see 108 and 109 to read with 120. Kindly see 108, which has been 108 at page 26. See page 26. 108. Lordship,
Yes.
108.
Yes.
A person registered in the electoral roll for a constituency relating to Gram Panchayat shall not be entitled to be registered in the electoral roll for a constituency relating to any other Gram Panchayat or in the electoral roll for any municipality or notified area authority as to be established or as to be constituted under any law. 109. No person shall entitled to be registered in electoral roll for more than one constituency. 2. No person shall be entitled to be registered in the electoral roll for any constituency more than once. So, So once you fulfill 108 and 109, so then you are a valid voter. And to be chosen to contest the election also 120. So you have to delete your name for either of the one, which has not been done. So there is no question to fill up the particular seat to be chosen to contest the election. So that, my lord, the provision was overlooked by the learned tribunal in my humble submission. That's the whole crust of the entire matter. Now, my lord will kindly look into one judgment was cited before the tribunal, which how is paragraph 31, he says that it is distinguishable, this judgment. But he has not made any comment or laid down why it is not distinguishable. Kindly see, my lord, that judgment. My lord, if your lordship kindly see para 3, my lord. See para 3. The facts. My lord, before propositional law, one has to know the facts. What is the facts? According to the petitioner, a petition was filed by R3 for quashing the election of the petitioner to the office of Ansal Committee member under 46 so and so on the ground. Petitioner was improperly declared elected unopposed due to respondent number 2 rejection of his nomination on the ground of double enrollment. It was an admitted position that private respondent number 3 name was enrolled as a voter both in Itanagar Municipal Council and 46 Das. The case of the petitioner is that while disposing of the case in favor of respondent number 3, the State Election Tribunal did not address the primary issue of whether double enrollment could be ground for rejection of nomination. It also did not decide the case on the vital point on whether rejection of nomination is strictly limited to Rule 12 to A to D of the Arunachal Pradesh Panchayat Raj Conduct of Election Rule 2001. The SCT did not decide whether Rule 12.4 returning officers shall not reject nomination paper on the ground of any defect which is not of substantial character. It's totally circumscribed by Rule 12.2A of the rule. Now, if you see dual voter, see para 6, my lord. See para 6. In the meantime, the government of Arunachal Pradesh issued notification for conducting Panchayat Raj election, including Gram Panchayat, Anchal Panchayat, Jila Parishad, all over the state, wherein the date of filing a nomination was fixed on 16/4/2013 and the date of polling was fixed on 16/5/2013. The case of respondent number 3 is that he, being a permanent resident of Sangwa village of Sanglai district, filed his nomination paper on 22/4/2013 for the post of district, Sanglai district. Filed his nomination paper on 22/4/2013 for the post of ASM from 46 Das constituency and independent candidate. The petitioner to file his nomination paper as INC candidate. It was alleged by respondent number 3 that the RO arbitrarily and illegally rejected his nomination paper during scrutiny on 25/4/2013 without rejected his nomination paper during scrutiny on 24/4/2013 without assigning any valid reason. Respondent number 3 was informed that his nomination paper was rejected on the ground under Chapter 4, Rule 2A, read with Arunachal Pradesh Panchayat Preparation of Electoral Rule 2002, Chapter 2. According to petitioner, respondent number 3 admitted his nomination paper rejected by RO due to double enrollment in IMC SL 46 Das Council. After rejection of respondent 3 nomination, petitioner, being the lone candidate in the fray, was declared elected as ASM from 46 Das constituency. So this is the facts. If you see at para 10, see para 10, my lord, now. Para 10.
Para 10 page. Okay.
Para 10.
248.
248. 248, my lord. Para 10, sorry, para 10. In the said election, learned judge of APC put his emphasis upon the issue number 2, whether rejection of nomination paper of the petitioner for Anchal Committee election of so and so is valid in law. Learned judge decided said issue in negative in favor of respondent number 3 as under. A close scrutiny of section 108 of so and so disclosed that in case of person whose name is registered in Gram Panchayat electoral roll shall not be entitled to be enrolled in electoral roll relating to other Gram Panchayat or the electoral roll of municipality or notified area authority. Thus, the prohibition is not in respect of enrollment under Gram Panchayat, but enrollment under the municipal electoral roll or other Gram Panchayat. It is an admitted fact the petitioner name is enrolled in the 46 Dadang Ansal Samiti constitution and his name is in the electoral roll of Itanagar, but not in other Gram Panchayat. In such case, the prohibition in respect of municipality and not in respect of Dadang Ansalik Panchayat. Now kindly see at page 25. See 25, para 25. The submission of the learned counsel, lots of got it, of response number 3 cannot be accepted for more than one reason. The ground and manner of rejection of nomination paper has been specifically provided in Rule 12.2 of the APPR Conduct of Election Rule, read with Section 67 of APR Act 1997. The manner for rejection of nomination paper by holding a summary inquiry is spelled out in handbook for returning officer referred to above. Petitioner name was not entered in two different Ansal Samiti constituencies, but in one Ansal Samiti comes the electoral roll and one municipal electoral roll under two different acts. After entry of the name or the petitioner electoral roll of Dadang Ansal Samiti, I do not find any entry in the name of petitioner electoral of any other Ansal Samiti constituency. Ground for double entry has not been incorporated as a ground for rejection of nomination paper under Rule 12 of so and so. Unless a double entry, one in respect of municipality and one in respect of panchayat is made ground for rejection by statute, returning officer has no jurisdiction to reject nomination paper on the ground on mere surmises and conjecture, that too without holding any summary inquiry. Now, if you see paragraph 26 is the see para 26 now. Two paragraph 26 kindly see. In terms of section 56 of the Act of 1997, one member of every Ansal Samiti, one member of the Ansal Samiti is to be directly elected from each Gaon Panchayat territorial constituency, and in terms of section 121A of the said Act, a person shall not be qualified to be chosen to fill a seat in a constituency of an Ansalik Samiti unless his name appears in the electoral roll of the concerned Ansalik Samiti. In the instant case, as the very enrollment of respondent fee, that is election petitioner, is in the constitution of 46 thus as well as Itanagar municipality. Therefore, the same is illegal in terms of bar provided in section 108 of the Act as well as 18 of the Act. Hence, the nomination of private respondent number 3 was rightly rejected by the returning officer. Now see para 30, my lord.
Yes.
See para 30, two paragraphs I'll read. The finding. Section 57 of the Act of 1997.
Para now?
30. Section 57 of the Act of 1997 lays down the
Das, let us read the earlier paragraph once again.
Which paragraph?
Just now you have shown.
26.
No, before 26.
25.
No.
25.
No, not 25. That paragraph 25.
25. That's right, 25. Therefore, if the present is registered in the electoral of a constituency of a Gram Panchayat, he is
now,
not.
what it said, the ground of double entry has not been incorporated ground of rejection of nomination paper under so. One in the municipality under the respective panchayat is made ground for rejection by statute of return had no jurisdiction to reject the nomination paper on such grounds. One, it says that he has no jurisdiction to reject the ground. And page 26, it says it's rightly rejected. What is this?
No, it's not. I'm sorry. No, the ground here, the returning officer doesn't have the jurisdiction. The jurisdiction is only based on the tribunal.
Okay.
That's based on the tribunal.
Okay.
Now, if you see paragraph 30, kindly see, my lord. 26 I have read.
Okay.
Para 30, kindly see.
Give a step.
Okay, Senchi. You should have time. What?
Staple, ভাল step. Good staple. Page paragraph 30.
30.
Yes.
Section 57 of the Act of 1997
Hmm.
lays down the ground for disqualification that for contesting an election to a panchayat, the candidate has to be first qualified. If his qualification by virtue of his enrollment in a panchayat constituency is not beyond doubt, he cannot be said to be qualified to contest the same. In the instant case, since the respondent 3 is admittedly an undisputed enrolled in both the so and so for 46 thus as well as Itanagar municipal constituency, he cannot contest as a candidate for the said Ansal Panchayat. A cogent reading of Rule 10 and 11 of the Arunachal Pradesh Panchayat Raj Rule 2002 and Section 108 Act of the Act shows that dual enrollment in voter list is prohibited, and making a false declaration in this regard is an electoral offence punishable under Section 117 of the Act. Number 33. With regard to the contention that a provision of the Act of 1997 are similar to that of Representation of People Act 1950 and Representation of People Act 1951, it may be pointed out there is a fundamental difference between the Act of 1997 and Representation of People Act 1950 and 51, respectively, insofar as qualification for election from constituency is concerned. Section 5 of Representation of People Act lays down the qualification for membership of AC Assembly. The said section read as follows, because that's a general law and this is a special law. Now, if you see at next page at para 34, now these have been laid down. What are the conditions of the Representation of People Act? There, my lord, absolutely there is no problem. Representation of People Act. Now see 34. For the reasons stated for above, nomination respond number 3 election petition rightly rejected, and to that extent impugn judgment order passed by learned election term is partly set aside. That's the judgment which has been passed, and this was placed before the tribunal, but that was said that it is distinguishable. My humble submission, it is not distinguishable because the moot point is that whether double entry. That's the case. Now, against the judgment, my lord, I have been told that a review petition was filed, 2 of 2017, and the last order. Where is the order? This is the order. They have withdrawn this review. To my knowledge, there was no appeal filed against this order. That's the whole case, my.
Yes.
So my submission before your lordship is that double entry is not permissible because it directly hits, if you read 2057, to be chosen to fill a candidate, so you have to look into 120. Now 120 and 57 has been read separately by the tribunal in the finding. But to read 57, you have to read 120 to be chosen, to fill up a seat. And that is what our judgment of this single judge. Now, if your lordship differs with the judgment, that's a different issue altogether. That is very honest to your lordship. That no, I don't agree.
Until and unless there are some Supreme Court judgments.
Yes, right. But now the Representation of People Act, that I will give a reply. It is not, because that's a law, general law, is a special law.
Not on
After
the general election. What is
No,
the
that's
meaning
like-
of to be chosen? To
Yes.
fill up and to be chosen as a member. What is the distinction?
That's why it's said, my lord, your lordship, the humble submission, chosen and fill up cannot.
One thing I can very well say, so far relating to the point, a person is not entitled to have two voters team. That is, he is not entitled. There will be penal provisions, but will that automatically disqualify a person?
No, that's a disqualification.
That disqualification will have to be done through if he is chosen to be a member in a different procedure.
No.
How a member of the Panchayat will be disqualified?
No, disqualification I have shown. If you
No,
see at
no,
57.
there are two concepts. Disqualified to fill a seat.
Yes.
Understand? And disqualified to be a member. Now, suppose a Panchayat member is elected. There is no challenge to the election. Suppose your client has elected. There is the voting remains. Somebody after election says that you are not qualified. Now, what is the procedure? This is not an election. Suppose you taken the oath and all. Now, the member of the Panchayat, somebody brings a thing that he is not qualified. Now, what is the procedure under this? That is to be seen. Yes. Because see, suppose you are a member of Legislative Assembly. You are holding the education portfolio. An existing contract is there between your firm, business entity, and the state of Arunachal Pradesh. Somebody brings a disqualification that he cannot hold the office. You are still the director of that company. So that a disqualification is brought in. That can be disqualification.
Yes.
Then that disqualification, there is a procedure followed. It will be to the speaker and all. So when under 57, a disqualification to be a member is given, what is the procedure?
No, there are two things. If your
There are
lordship
two
can-
things, that's
Two
right.
things. No, I said that's right. One is to be after election,
Hmm.
and to fill up a seat. You may
So
be.
can you club up these
No,
two
that's right.
concepts?
Two. What I am saying, my lord, my objection to the returning officer was that you cannot, his nomination cannot be accepted. To be chosen to fill up that particular seat because he is double. He has a double.
Understand?
Yes.
Understand? Now he is disqualified. Now can an election petition is a remedy? Or a remedy lies somewhere else
No, it is
for
a-
his removal?
No, for his removal is no, what we are saying before the election tribunal, his nomination papers should not have been accepted.
We understand.
Removal is different.
No, we
His
understand.
nomination papers should not be
Therefore,
accepted.
if removal is different, should we bring 57 to 120? Or we will have to read both in conjointly 57 and 120?
57 has to be read
Read
with
with conjoint. This is your
That's
argument,
my-
and according to you, that
Yes.
has been clarified in this judgment.
Yes.
And this is binding upon
Yes,
this
binding.
court unless
your lordship
Yes.
takes and there is a judgment of the Supreme Court
or
also
we
distinguish, differ this particular
Yes.
judgment.
yes. Tiwari.
So, my lord, the first argument,
Hmm.
section 57 must be read conjointly
The
with
first thing
section
tell us
120.
what do you
I'll come to
say
that.
about that judgment?
Judgment is per incurium, lordship will just ignore it.
Okay.
My lord will ignore it on three counts. Number one, the concerned judge, my lord, totally misconstrued and misinterpreted and misunderstood the very scheme of section 120 after amendment 121. It was amended, my lord, 120 was amended in 2018 itself. Election was in 2020, so actually it ought to have been 121. Be that as it may, my lord, there is no change between 120 and 121. For the sake of convenience, we will call it 120. So, my lord, misconstrued, misunderstood, and misinterpreted the very scope.
Misconstrued, misconstruction, misinterpretation,
And misunderstood.
Misunderstood. Can that be can a per incurium judgment be based on that? It can be in ignorance of law.
My lord, if it is a statutory provision, then, my lord, it can be called per incurium, though learned single judge was aware of this very particular act. But totally misdirecting oneself from the provision may tantamount to per incurium. That's number one. But number two, I will say more importantly, learned single judge confused the two expressions, disqualification, not being qualified.
That argument
I'll
is
come on
not.
per incurium because in Pothula Ramarao, Supreme Court considered this very aspect of the case and said disqualification and not being qualified are two different things.
You saw that.
And I'll come to
That-
the Pothula Ramarao.
Okay.
And not only Pothula, first of all, Pothula Ramarao was simply ignored, was not even looked into, it was never placed, not considered. But even the Babu Rao, which has been relied on by the concerned judge, Babu Rao also, learned single judge, thoroughly misdirected himself in understanding the true intent and the purpose of Babu Rao.
Okay.
So the Supreme Court judgment, my lord, either you ignore it or you totally misunderstand it. Either way, the judgment would fall into the category of per incuriam. And thirdly, not a ground for per incuriam, but a ground for distinguishing it. In the Chera Loma case, no request was made by the concerned candidate to the returning officer to delete his name from the other constituency. Over here, the request was made, in writing the document was given. Subsequently, my lord, in fact, the document was also introduced in the proceeding by way of an affidavit. There was argument on that, affidavit was allowed, it was made part of the record. By an RTI application, in fact, we obtained the copy of the consent application. We had requested that delete my name. And it was the mandatory duty, statutory duty of the concerned
So
officer.
that will be a different argument.
But
Then you'll have
yeah.
to accept that yes, the two cannot be, but then you'll have to.
No, I'll come to
that
that.
will be two
This
different-
argument would be relevant for the purpose of my case for one particular reason. The argument would be relevant for the fact that if it is a violation of the mandatory duty of the concerned officer, electoral officer, it is his duty, and that would not entail disqualification
Mr.
of me.
Tiwari, that argument presupposes that dual entry in the voter list vitiates the election. That will presuppose if you go to that argument.
It can also be argued, I'll put it conversely. Conversely, it can be argued that a duty which is casted upon another agency. No, I'm coming to that. Conversely, same argument I'm taking, which Lordship has given to me, and I'm converting it. Conversely, it can be argued if a third agency, which is a statutory agency, is casted with the responsibility of doing a particular duty, if that duty is not done, that duty would not entail or vitiate my election, and that is how the particular provision has to be read. The provision is not mandatory. That is what is relevant for this case.
That is what I'm
120
saying.
is not mandatory.
So
That is why not being
so
qualified.
If it is not mandatory,
Yes.
there is no relevance whether you have applied or not applied.
Correct. But it shows the bona fide conduct.
No, that will not
Either
go.
way. Very well.
That will not go.
Agreed.
If you say it's mandatory, then
It is not mandatory. I'll come to that.
If you argue that it is mandatory, but there is an exception when there is application.
I'm arguing both.
So how-
No, my lord, I repeat, I'll put it this way. My submission is going to be section 120 is not mandatory because a strict interpretation of section 120 and reading compulsion into such a provision would lead to a situation wherein violation of statutory obligation by a third agency would lead to vitiating someone's election. It's like this. A statutory authority is casted with a duty.
But at the end of the
And
day,
that
we'll-
duty is
at
not
the
done.
end of the day, we'll have to remind ourselves we are in a judicial review of a decision made by a competent election tribunal.
Yes.
Whose decision perversity is not there. Here is a absolutely legal issue, whether this is mandatory or not. That's all. So those things will require examination of evidences. Examinations of evidences will be there. The question will be there whether they have acted or if we go by your argument,
Is there.
if your argument is there, then we'll even go to the stage that whether application was properly addressed, whether they have rightly not considered his application was not complete, then all arguments will be there, which we are not going to do in this case.
In fact, I'll just.
So,
I'll clarify.
so you first
I'll clarify. My lord will find from the records. My lord will find from the records. These documents are there. Just see. These three documents. Lordship will just have a look. This is part of the record. In the record, it is there.
So let us take the
I'll
first,
come to,
let
I'm
us-
just,
let
I'm
us-
clarifying a
let
particular
us,
position.
Mr. Das's argument is
I'll-
that
I'll-
this is essential qualification and moment you fail it, you cannot be chosen.
This
you may be
argument I
part-
will-
You may
This
participate in
argument
the
I will
election.
attack. This argument I will attack. I would say 120 is not
So
mandatory.
let us go to first that, then
Yeah,
we'll come to
I'll
other.
come to that. So, my lord, my argument will be 120 is not mandatory. And I will argue on that. This is just to show
Yes.
that application was made. He did not do his duty
Mm.
and it remained accidentally. It was accidental presence of the name in a different constituency. Now, my lord, straight away I come to this. The argument, the expression is a person shall not be qualified to be chosen to
Section
fill a seat.
57,
Section 120.
120,
I'm coming to 120 itself.
120. Okay. So let us-
57 is a disqualification.
Hmm.
Disqualification straight away, my lord, at the very threshold it goes. I do not fall into any of this. I attract any of the provision, I am out.
Section 120, yes, read it.
120, which is 121 in fact. A person shall not be qualified to be chosen to fill a seat. There are three words: not be qualified or not being qualified to be chosen to fill a seat. These are the three words. Number one, unless A, his or her name appears as an elector in the electoral roll of the concerned constituency. So my name must appear in the concerned constituency from where I am contesting election. If my name doesn't appear, I am not qualified. Number two, he or she has completed 21 years of age. C, a person shall not be qualified to be chosen to fill a seat in more than one constituency of a Gram Panchayat, Anchal Samiti and Jila Parishad. So my name must be there. And secondly, not from two different constituencies. So C presupposes a situation. C presupposes a situation that my name may be present in the electoral roll
You
of two
cannot
constituencies.
participate in the
Yes.
from two constituencies.
Yes, so I will interpret it to mean that nomination paper can't be filed from two constituencies and I cannot contest election from two constituencies. The moment I file nomination paper from two constituencies, nomination paper will be filed on the strength of my name being present in the electoral roll of the constituency. The moment my nomination paper is filed, there can be an objection. His nomination paper is also there in the other constituency. He has filed nomination paper here also. That can be rejected. Likewise, accidentally, if my nomination paper is cleared in both the constituency and I contest election, my election from both the places will go because I did that. Over here, the petitioner, sorry, the respondent, he files nomination paper only from one constituency. He contests election only from one constituency and is declared elected from that constituency. So where is the question? And to me, to my mind, my lord, this is the correct interpretation. Chosen to fill a seat. Otherwise, we could have used a different expression. Filing a nomination paper, contesting an election and winning an election. Here is a case wherein the petitioner did not file his nomination paper in two different constituencies. Had it been a case, could have been rejected. This is a simple interpretation. And no other interpretation is possible. Interpreting it in a different manner will create difficulties. Because, my lord, it happens everywhere. In 90% of the cases we find, even in Assam, person's name can be in two different constituencies. In Panchayat also it happens. If that is treated to be a disqualification. Now in Naval Kishore case, the Supreme Court said, disqualified and not being qualified are two different things. Don't confuse it. Not being qualified, if there's some provision is attracted, that would not entail to vitiation of the election. I'll come to that proposition of law. B was not an issue here at all. It was only A and C. It is C primarily. because my name appeared in the Ganga constituency and I contested election from there. But accidentally, my name in Tora constituency was not deleted.
Mr. Das, you have relied on 57.
No, this.
I'll come to 57.
Tribunal has-
57 no whisper.
Just let it have it.
Tribunal has relied 57.
Huh?
57, tribunal has relied 57.
No, 57. What you propose to say from 57?
57, what I said, that for the 57 opening, a person shall be disqualified for being chosen. So first,
So chosen as, okay.
so for being chosen to be a candidature of a particular
Okay,
constituency.
understand.
Yes.
And for being a member.
Then, I'm sorry.
And we are reading it.
Yeah,
A
and for
person
being,
shall-
so comma, first, my lord, that has to be satisfied.
Okay, fine.
Then, and for being a member of a Gram Panchayat, Anchalik Panchayat is not so, these are the, my lord,
Conditions.
yes.
Where is that conditions that there should not be two voters?
No, he doesn't say, here in 57, that's the whole case. 57 doesn't stipulate, otherwise it would have been clear 57 is stipulate. 57, for disqualified, I come with a nomination for scrutiny before the returning officer. I say that his nomination should not be allowed. His nomination should be allowed because he is not qualified to be chosen or he is not qualified to fill that seat. So under 120. So where is the question? That's what I am saying, my lord.
Okay.
Disqualification, 57 doesn't stipulate that two voters. But if you read 57, first to be chosen to fill up, then 120 has to be seat. That's my first objection which I raised before returning officer. You cannot accept the nomination paper. You cannot accept the nomination paper because his name appears in two constituency. So double entry is there. That's my first objection that has been made.
Yes.
Well, let us now proceed systematically. The first thing which is to be appreciated in this case is, unlike the Representation of People's Act, and not only the Representation of People's Act, but in many other Panchayati Raj Acts of other states. I have seen some of the states like the state of Maharashtra and also the state of Rajasthan. In those states, the Panchayati Raj Act itself contains a provision where on certain grounds being attracted, election can be declared void. The grounds for declaring an election to be void, A, B, C, D, etc. So far as Arunachal Pradesh is concerned, here there is total silence in the act about the grounds on which election can be declared void. Now, my lord, if the act is silent about the grounds on which election can be declared void, does it mean that election cannot be declared void? Well, the answer will be certainly no. Election can still be declared void, but then the grounds on which election has to be declared void would have to be tested on the touchstone as to whether on this ground election can be treated to be vitiated. Here, my lord, the standard principles are if one attacks a disqualification, then ipso facto clearly it goes. Election will not survive, the person cannot be declared elected. So disqualification would always remain a ground. Apart from disqualification, what other grounds can be there is subject to judicial interpretation and a situation. And that judicial interpretation has to be tested on the anvil of as to whether having attracted this very particular provision could entail election getting vitiated. If this be the touchstone on which particular case is to be tested, my first submission is going to be in a situation where two nomination papers have not been filed, but only one paper has been filed. The place from where the nomination paper was filed, in that place, the concerned candidate name does appear. Merely because his name appeared in another constituency would not be a ground vitiating the election on which election can be declared void. Because the presence of one's name in a different constituency and not deletion of that very particular name, for that I will show the provisions. There are provisions. There is a duty of the registration officer, either on his own motion or on the application. Suo moto he can do it. And even the third party can make an objection that why someone's name is here, his name is also there. That can be also a ground for ERO to cancel the name. Over here, neither of the three requirements were done. Sorry, the two were not done. I made an application. My application was received. They did not act upon the application. It is too much to expect that one would pursue that and see to it that his name does not remain over there. My humble submission would be this can't be the scheme of the act. That one has to ensure also that whether one's name is present in the other constituency or not, if it is present, one has to pursue that and see to it that his name gets deleted. Otherwise, he will not file nomination from this constituency. This can't be the scheme and the purpose. At the very outset, below, any suggestion on this aspect to the contrary would be preposterous. This is my submission. So therefore, it is not mandatory. It is mandatory if two nomination papers are filed. It's the situation, Mirad. One can, is in a given situation, a provision can be a mandatory. In a certain situation, it will be treated to be not mandatory. If two nomination papers are filed, I am out, attracted. But if only one nomination paper is filed, you can't bring this provision to ensure cancellation of my election, cancellation of my candidature. Because I have not failed in my duty. I have done whatever I was supposed to do. And I am declared elected. So this would be the submission. My lord would also take note of the fact that in paragraph 30 of the judgment, the tribunal has recorded the fact that the winning candidate had pursued the authority, had filed the application. It was not acted upon. Now, straight away, my lord, I'll go to section 57. Section 57, I need not even read. Lordship has taken note of the fact that all the provisions of section 57, there is no whisper so far as 120 is concerned. Any of the situation is not mentioned over there. And I accept the principle that if 57 is attracted, any of the ground they are in, I am out. But here, there is total and complete compliance of section 57 of the Act. Now, straight away, my lord, I'll turn to, the Lordship may have this, only the provisions. Because all the sections are put it, right? Nothing. Lordship will have this kind just for benefit, because it becomes very cumbersome, different sections.
What are the other sections, Mr. Das?
That's why I'm giving it one, all the relevant sections I have noted. One interesting section would be, my lord, in different categories. The first category you have here marked is no person to be registered in the electoral rolls relating to more than one local authority. This is 108 in the Panchayati Raj Act.
Yes.
In fact, in this case, this is also attracted. More than one local authority, because over here, my lord, it is Ganga as well as Toru.
Yes, sir, too. You'll have to address on this judgment also.
Yes.
Nowadays, what my learned friend said, that ignore this, ignore that. I think.
Ignore, I will say, if my lord doesn't
Very-
agree, the one option is always
very careful,
available,
because
referring it to larger bench. for
Punjab and
consideration.
Haryana High Court judge, that day, they have issued a contempt Supreme Court. My learned friend, not using word, but he said a rubbish judgment has been passed.
So
and so.
that is not the language I have used.
No, you have not used, that's why I am saying. Nowadays it is
But,
more difficult.
But
Nowadays
Justice
is,
Devashish Barua, I remember
nowadays
distinctly.
is more
In
difficult.
one particular case, judgment of a concurrent bench, single bench, he says, I don't agree, gave his reasons and deviated.
No, that's a different, my lord.
No, see, I am a believer of judicial discipline.
Yes, right.
But I would
I have 2-3 judgments I have authored. I have agreed why I have agreed and what is the judicial discipline I have held one of the judgment I think here is. But immediately after becoming judge, maybe within 15 days, I have referred also judgment to larger bench when I did not.
So here, my lord, both the courses are open to your lordship. My lord may refer it to
Both
larger
the
bench.
courses are open to you
And I would also say
And third course is that if I can have a dot judgment from the Supreme Court, I can ignore this. Very well. Both.
Yes, let's see.
Yes. Where is the petition? Yes.
Yeah, my lord.
Yes.
My lord,
Where is standing counsel education? Call him, call him. Yes, tell us.
Yes, my lord, I filed this application under 227.
What are your
226 of
grounds?
the- Yes, my lord.
What are your grounds?
So, my lord, the first ground is that it's a political punishment. The transfer has been made. Because, my lord, immediately after the ensuing general election, there were mass transfer going on. So, it was not on the ground of seeing the welfare of the education. It was basically to punish those people who are from the opposite side. And the petitioner here, my lord, he is the brother-in-law of the losing candidate. So he was already aware that there is a possibility that I might be transferred.
And what is the other ground?
My lord, medical grounds. He is right now he is in Puchikeko block, my lord, and he has sustained multiple fracture recently, and because of that, surgery has been conducted on his leg. So the place of posting where he is being transferred from there, it is not the medical facilities are not accessible, my lord. And he is also a pre-diabetic patient, my lord. So he have to consistently on regular intervals need to go and visit the medical clinic also. Because of his place of posting, which is basically a punishment posting, it is not possible for him to access the medical facilities, my lord. So this is the second ground which I'm tracing before my lord. And my lord, there are two WT messages.
No, I've seen that. WT messages that
Yes,
banning.
my lord. Banning, and immediately after
Yes, we have passed an order on earlier today morning. Item number? What was that item number?
Your Honor, just now only I received the copy of the petition, Your Honor, and
Okay.
and I'm appearing on behalf
The
of.
present application is filed
my lord, I'm praying for interim relief, my lord.
assailing an order of transfer dated
31/7/2024.
31/7/2024, whereby the petitioner is sought to be transferred from
Puchikeko block.
where do you get that? That also you have not written in the synopsis.
It's
All to the judge.
no, my lord.
Huh?
My lord, from Puchikeko block, Kamle district.
How do you get that? You'll have to get to the transfer order. Where is the transfer order?
Transfer order is, my lord, in
Everywhere you have written white order dated since I have been transferred. From where to where?
my lord, transfer order is page number 18, my lord.
Page number
18, 18.
18.
Serial number 7 is the petitioner, madam.
From has been transferred as BRCC Raga.
Yes, yes.
Huh?
He was holding the post of BRCC, and from that he has been transferred to Hankar village.
What is your present substantive post?
Is TGT right now, my lord. It's a BRCC block.
No,
resource code.
BRCC is an additional. What is your
TGT?
TGT of which school?
It is TGT of Puchikeko.
The petitioner who is holding the post of BRCC Raga has been. So you are posted to the respective school.
Yes, from BRCC, I was holding the post of BRCC. From there, I have been transferred to.
BRCC was a selection post or on application you are appointed?
No, I was just appointed, my lord.
How, what is your right to continue as a BRCC?
Yes, my lord.
Huh?
I'm sorry.
What is your substantive post is at that post school in Sipu?
Yes, yes, yes.
Is that it?
Yes, yes.
That is your substantive post?
Yes.
You were given additional charge as a BRCC
BRCC.
without any selection
Yes.
on an application made to the local authorities.
Yes, madam.
Is that it?
Yes.
Now you are continuing. Now they want you to go to the place, you go there, that's all.
No, my lord, but the manner in which they have rendered this transfer, I'm telling you.
What is your right to be BRCC? Is it not a due selection which is otherwise required? Which is otherwise required to be selection. Once upon a time you have been favored to become a BRCC. Now that favor is withdrawn.
No, my lord,
Tell us the right to continue as a BRCC. And where is your statement? How you were selected as BRCC? Tell us.
my lord, I was appointed in the year of 2014 as BRCC, my lord. Based on
what?
uh,
Recommendation of somebody.
no, my lord, they have. I filed one application, my lord.
That is what we are examining that.
Yes.
One person will come fine morning and say that I want to be BRCC. This is how central government monies are being spent here.
My lord, here, but after the.
And he will be pick, okay, you want to be BRCC? Okay, you be BRCC.
My lord,
in the same manner, no ceremony to appoint you as BRCC, no ceremony to transfer you.
my lord, I'm just simply stating that the place of posting, it is really difficult for me, my lord, to from there to have the medical checkup also. It's a punishment posting basically, my lord. And during rainy seasons, the place that hunger, it is inaccessible, my lord.
Challenging is transferred as BRCC Raga to the GUPS/SIPU.
Yes.
Full stop. The fundamental ground of such challenge is that the transfer has been issued, the petitioner being not a supporter of ruling dispensation, as well as for the ground that the petitioner is presently hospitalized.
No, not hospitalized, my lord, but
when operation was done?
my lord, come to page number.
Don't come to page, tell us when operation was done.
Operation, my lord, 2023 in the year.
Then.
But my lord, if you see, my lord, the X-ray
And
report,
the other ground, the health condition of the petitioner,
Yes.
who stated to be having difficulty in walking due to his multiple fracture is in his leg and repair thereof. Full stop. List this matter on Friday. The learned council education shall obtain instruction.
my lord, there is no interim. My lord, if the interim is not passed, then he will be transferred by tomorrow. Then
If it is transferred by tomorrow, we'll reverse it. If there is a good ground. Till Friday, status quo as on today be maintained. These are not the cases. We are holding them. We have fixed the motion matter on next Tuesday. How they are appointing BRCC, they will have to give a detailed affidavit. Tell your council, senior, we have already passed an order.
Yes, my lord,
And who sponsors this scheme? BRCC and CRCC. Yes.
status quo will be maintained, my lord. As
I have given a direction. Status quo as on today.
deeply obliged.
As on today shall be maintained as regards posting of the petitioner till Friday next.
Deeply obliged.
Yes.
May it please your lordship. Not in this case, my lord, I am.
Yes.
I'm before your lordship.
Difficult.
Very narrow premises, I understand.
Very difficult.
I understand. Lordship, what has happened that lordship will kindly see the last.
Both the cases very difficult.
I-
First case, at least.
Very limited prayer that my representation is pending. When I'm offering them
What
money.
representation?
No.
There is an way, there is an
I am-
order.
that is
Who can
I'm
consider
not
a
saying I'll
representation?
not pay money. Now what I'm praying before this court that they have not taken physical possession. Now they are after physical possession. They have put this property on sale. Sale failed. Twice it failed. So I am agreeable. Lordship can also record my statement that as and when if they are able to conduct any sale, at that time I am ready to give away possession. But if I am trying to settle the account and I am offering them money, they have not passed any order. On
Where is the bank?
Bank, no standing counsel is there.
Where is this? Where this bank?
SBI, it is served, it is the stressed asset Guwahati. Bamani Mudam.
Serve a copy, come back on Friday. Nothing will happen on Friday. Till Friday, nothing will
Tomorrow, they
happen.
are asking the report tomorrow in this first case. Second
They
case,
will give a report to the recovery officer. You know very well what happens in recovery officer's
that's
office.
the difficulty. They don't. want-
Nothing will happen in the recovery officer's office. Somebody will file an adjournment in the morning and go whole day roaming the Guwahati doing court cases. In the evening, recovery officer will pass adjourn.
My lord, as a lordship, please.
Yes.
But.
Otherwise, it's very difficult.
I know, my lord, very
Yes.
narrow premises. Let's say
Uh,
they are not able to sell the property. So what taking possession will
No,
not.
sale, is this any auction is fixed?
No. Now
Then-
it is no, but now they are asking for possession. They will not serve their purpose. Now if I am ready to pay you some money and then 50 lakhs he has offered, instead of insisting for physical possession, they
What
can-
is the total amount?
Total amount is 137, 1 crore 37 lakhs.
At least 75.
So
Then we can consider till the next day.
they have not said anything other than 50 lakhs. I have also.
Okay, on Monday, we are taking it up Monday. The petitioner is a borrower under respondent bank. And the loan had become overdue, and accordingly actions were taken under the what is that act, original?
It is Recovery of Debts and Bankruptcy Act of 1993.
No, not SARFAESI.
No, it is not SARFAESI.
That is the recovery of
Recovery of Debts and Bankruptcy Act of 1993.
Recovery of Debt and Bankruptcy Act 1993. Full stop. Now the bank is in the process of taking possession of the mortgage property. It is the case of the petitioner that the petitioner want to settle the dispute and is ready to offer 50 lakhs deposit against the total due of 1 crore 35 lakhs and 1 crore 35 lakhs. Full stop. This court is of the opinion that before any interim order is passed, bank should be heard in this regard. Full stop. Accordingly, let this matter be fixed once again on Monday. In the meantime, the petitioner may serve a copy of the writ petition upon the bank. Respondent number?
It is stressed as it is respondent number 1.
Respondent number 1. Respondent number 1.
Yes, ma'am.
Intimating that,
No. Stressed.
intimating the respondent bank that the matter is fixed for further consideration on Monday, and the interim prayer shall also be considered on that day.
Well, 1 and 2.
1 and 2, huh? Shall be considered on that. First of, after service of notice, let the petitioner file an affidavit in proof of service before Monday. First of, list accordingly. Same order in the second case. Here amount is something different.
Amount is different. Amount is
Amount is
52 lakhs.
52 lakhs. And ready to pay how much?
We are offering 35 lakhs.
35 lakhs. In the other, out of 135, they are offering 50. Here, out of 50, they are offering 35 lakhs. Rest will be saved. But this orders, you will have to do it right now. She will leave the, I'll sign it here on. Now.
My lord,
this
can
will-
it be on Wednesday, my lord?
Wednesday. Wednesday is a working day,
Yes, my lord, it is
Yes.
14th of August.
40th, okay. Yes, you may go. It will take some time, your case.
10 to 15 minutes.
Okay, 10 to 15.
Recess helped me to
We
organize my
think, we
thoughts.
think we should fix.
2:20 to 18, permit to wheel watch, 20 minutes, huh?
Oh, yes.
Yes, I will
Uh,
just see the watch.
But
No.
I think better to fix for further hearing tomorrow
My lord,
for
If-
everybody's interest.
I'll take 15 to 20 minutes. Whatever questions my lord will ask me, I will answer.
Huh?
Whatever questions my lord will ask me, I will answer.
Mm.
But recess helped me to organize my thoughts.
Mm.
Because, my lord, I was lost in jugglery of words
Mm.
in the course of interaction. I'll make pointed submissions, one after another.
He said,
Sure, look at the watch.
Mr. Chaudhary said, my lord, father is important.
That's why.
Very
I'm
well.
saying
Look at
further
the watch.
hearing is important. These are legal issues.
Okay.
We may refresh our mind
Sure.
tonight and we'll get back tomorrow to
But
have, if anything to be added.
Very well. But I'll call upon my esteemed colleague to look at the watch. I'll also take care of the watch.
Okay.
My first submission, my lord.
Yes.
My first submission,
Bullet point.
section 120 is mandatory.
Mm.
But the plain language
Mm.
of section 120C is, what it means is, two nomination papers can't be filed from two different constituencies, merely because your names are there in the electoral rolls of two constituencies. If filed, liable to be rejected. This is the plain meaning of the word, shall not be qualified to be chosen to fill a seat. This is the meaning of 121C.
Yes.
It's a mandatory provision. The coordinate bench, my second submission. The coordinate bench in Chira Loma case carved out a new ground to declare the election void by reading section 108 of the Panchayati Raj Act and brought in section 121C in aid of 108 to arrive at a conclusion that since 108 says, and I take your lordship to 108, 108, the provisions I had given to your lordship. I have not quoted, but then I have referred to 108. 108 says, no person to be registered in the electoral roll relating to more than one local authority.
So your argument would be, just before
Yes.
you go, your argument would be the disqualification may be chosen or may be to fill is advices under 57 and 120. And in both the cases, there is no prescription that you cannot have two
Yes.
names in two
That's
constituencies.
it.
This is your case.
I cannot put it better.
That's all.
Exactly. This is what it is.
This is your case.
Now, I just
Therefore, if we read both and if we read both to be mandatory and if we club all the conditions together, then also 108 nowhere comes within the
Yes.
purview of 57
Yes.
and 120. That's
Yes.
all.
Yes. Coordinate bench, referring to 108, says, look, 108 is a prescription that one person can't be registered in two different local authorities.
And that is brought to be a disqualification
And by way of
read into the legislation
Yes.
of 120 and
120C was brought in
57.
in aid of 108. This is what 108 is. So it's not permitted.
That we understand.
Yes.
But that has been,
I'll
a
come.
provision is read down by a coordinate bench.
I'll come.
How to
I'll-
that speed breaker, huge speed
Yes.
breaker to overcome?
It has been read up practically, not read down. It has been read up. It has been read to me what it never meant. I'll put it this way. The coordinate bench read it in the manner it was not meant to be read. No aid of 108, no aid of 120C could be taken to make 108 a disqualification by itself.
No. What I'm asking is, that is an interpretation.
Yes,
What
I'm
ought to be done, what ought not to be done, whether it's correct or wrong.
Well,
I am not asking that. I am asking something is read down or read up whatsoever. It is not that 108 is not taken note of and some
I'm dealing with it, that's
So,
why. The chain
all
of
are
thoughts.
taken note
Got
of,
it.
dealt with.
I'm
and-
coming to the
and a
judgment.
a decision
I'm
is
coming
taken.
to the judgment.
Okay,
I'm coming
so
to the-
therefore, why this court should not follow that
Yes.
judgment following the
Judicial discipline warrants it.
Yes.
I'll come to that. I'll just
Even
very
if
quickly.
even if it is assumed that
Oh,
I am
yes.
having a disagreement.
Okay, very good. I'll come to that.
Yes.
So my two submissions are over. Number one, the plain meaning of 120.
Yes, that will
1C.
fine. That is
The
fine.
second, 108. 108. To support 108, 120C was brought in and a new ground was carved out. Second submission, which ought not to have been done. Now, the third submission. The judgment of coordinate bench was in connection with 108. Present case is also 108. Coordinate bench, that's my third submission. Coordinate bench said Babu Rao is distinguishable and moved away. I would say the Babu Rao judgment was binding on coordinate bench, and coordinate bench merely by saying Babu Rao case of the Supreme Court deals with the representation of People's Act, therefore it is distinguishable, is not permissible. Simply because Section 108 of the Panchayati Raj Act 97 is perimeteria with Section 17 of the RP Act
Of 17?
Section 17. 17.
Just a minute.
Of the representation of
Just
people
a
Act.
Section 108 perimeter.
I have written.
Section
17
17. Okay.
of the RP Act 1950. I'll just note RP Act 1950, not 51. Yes, my lord. Section 17. No person to be registered in more than one constituency. No person shall be entitled to be registered in the electoral roll for more than one constituency. Here, 108 says
same.
Two local authorities or
Yes, that's same.
practically. So now the fourth submission I come to Babu Rao. And then Babu Rao was reiterated in Pothula Rama Rao, which was never looked into by the coordinate bench. If my lord is not, if this submission is not acceptable to my lord, then I would submit, lordship may consider referring the judgment of coordinate bench to larger bench. But if my lord is satisfied that Babu Rao principle and Pothula Rama Rao principle was binding on the coordinate bench, then my lord will follow this principle as a proposition of law. Now the Babu Rao. Babu Rao is 1999 5 SCC 38.
1999.
1999 5 SCC.
5 SCC.
Page 38.
Page 38.
Relevant provisions, the ratio, para 14, 15 and 16.
Para 14,
15 and 16.
Okay.
38.
Babu Rao.
Page 49, internal.
Yes.
I just read below 14, 15 and 16. On a careful perusal of the relevant provisions as extracted above, we are of the view that the High Court was right in rejecting the contention of the appellant that the first respondent was disqualified to contest the Nilanga constituency as his name was found in two constituencies. We generally agree with the conclusion arrived at by the High Court. However, we are not in agreement with the view taken by the High Court that Section 17 and 18 of the 1950 Act are not mandatory. For the purpose of the 1950 Act, they are mandatory. For example, to object to the inclusion of the name in the electoral roll. One can object why the name has been included there. Then I proceed further. There is nothing to suggest in Section 16 of the 1950 Act that if a person's name finds a place in more than one constituency, that would automatically entail disqualification from contesting in any one of the constituencies. It is relevant to note that Section 21E of the 1951 Act refers to disqualification under section 16 of the 1950 Act alone while interpreting the word elector and has not mentioned any contravention of section 17 as disqualification. Contravention of section 17 as disqualification. No doubt, section 17 of the 1950 Act expressly states that no person shall be entitled to be registered in the electoral roll for more than one constituency. But if a person's name finds a place in more than one constituency, does it automatically entail the disqualification under section 16? We do not think so. Objection under section 17 could have been successfully raised to prevent respondent one's name from being included in the Nilanga constituency. So this would be an objection, not to include his name, but he won't be disqualified. Same, elaboration of further in para 16. Then I come to Pothula Ramarao. Pothula Ramarao, 2007, 11 SCC, page 1. Para 10 and 11. Now, my lord, I just clarify that Pothula Ramarao case was in respect of section 109. Sorry, Pothula Ramarao case was in respect of section 18 of the Representation of People Act 1950. Now, what is section 18? Section 18, what you will see that is there. Section 18 is no person to be registered more than once in any constituency. In one constituency, your name should not appear twice. But principle is the same. Here, two different constituency, in one constituency. So, section 18 of the RP Act 1950 is perimeteria with section 109 of the Panchayati Raj Act 1997. I have given that in my that 109 perimeteria with 18. Now, Pothula says what? Pothula 2007 11 SEC page 1, para 10 and 11.
Yes.
This I read, para 10 and 11.
Yes.
The second ground urged by the appellant.
Just a minute, just a minute.
I'm sorry.
Paragraph 10.
10 and 11. Internal page 7.
Second ground.
Yes. Straight away 11 I come to. In this context, para 11.
Para 11.
Para 11. 10 also, my lord, is both are, is the ratio practically. 11 I read because Babu Rao was referred. In this context, we may refer to a decision of this court in Babu Rao versus Manik Rao, where a somewhat similar question was considered. In that case, a candidate's name was entered in the electoral rolls of two constituencies. This court held that the mere fact that the person's name finds place in more than one constituency does not automatically entail disqualification under section 16 of the 1950 Act. Be that as it may, the High Court therefore rightly held that even if the allegations were accepted as true, that would not constitute improper acceptance of nomination and therefore would not constitute a ground for declaring the election as void. Para 9 of the election petition was rightly struck off as not disclosing such and such. So this is it, my lord. In Pothula Ramarao, they reiterated the same principle. Para 10 also I may read. The second ground urged by the appellant was that the returning officer ought to have rejected
Paragraph 12.
Para 10. Because 10 I did not read earlier.
10 second ground.
The second ground urged by the appellant was that the returning officer ought to have rejected the nomination of the first respondent as his name was entered twice in the general electoral roll for number 72 Koviur's Assembly constituency at serial number 797 and also at serial number 802 of part 50. Section 18 of the Representation of People Act 1950 no doubt provides that no person shall be entitled to be registered in the electoral roll for any constituency more than once. But the question is whether, and this is important, but the question is whether the nomination of a candidate is liable to be rejected if his name is entered in more than one place in the electoral roll. If the name of a voter is entered more than once, the consequence is that it can be corrected.
Double entry of the name of a citizen in the electoral roll of a constituency is not a ground of disqualification.
That is it. So now, my lord, my last submission would be the view taken by the Supreme Court in connection with section 17 and 19 of the Representation of People Act 1950, which is perimeter area, to section 108 and 110 of the Panchayati Raj Act 1997 has to be seen in the light of the safeguards, the built-in safeguards, namely at serial number 7, my lord will find scrutiny of nominations, and 8, correction of entries in the electoral rolls, and also 9, period for lodging claims and objections for inclusion and objection to entry in the electoral roll. So provisions are mandatory, but mandatory for whom? For that purpose. You inclusion, exclusion, you object, etc.
Yes.
These are the things meant for electoral registration officer. Here, para 30 of the judgment, again I refer to, the tribunal took note of that very particular fact. Here, whatever I was supposed to do, I had done. But even if I had not done it, this was the responsibility for the other person to look into that. Opposite party also could have filed an objection, exclude his name from the constituency. So, my lord, I rest my
Now,
case here.
how the judgment is dealt by the learned single judge?
The learned single judge simply said the
Which-
Babu Rao,
Which paragraph?
para,
Huh?
33. Para 33 of Cheraloma. Where is Cheraloma? If my lord finds that judgment is creating a difficulty, I would urge my lord to refer it to larger bench for consideration of this question. But I would submit, lordship can take a view that Babu Rao principle of law and Pothula Ramarao principle of law was binding on learned single judge. And there could be no deviation there. There is, Arey Baba, I had my book printout. 35.
Yes.
Mera printout.
Yes, yes.
35.
Okay, time is over.
Oh, no, see, but, so I'm answering my lord's question. I am answering the question.
Yes, that's. Anything you want to add?
Para, no, I'm sorry, my lord.
Part 33. I've read it.
Oh, that's it.
I've read
I
it.
rest my case there, my lord. So I have to for
Before you
submission
can
lastly.
open the book, I have completed the paragraph.
I couldn't get it. I lost my judgment.
Yes, yes.
So, my lord, in fact, I'll just sum up. My submission is number
You
one.
give a bullet point tomorrow. Or are you leaving?
Two lines only, 2 lines.
No, no.
For the benefit.
That 20 minutes you have argued on bullet points, is not it?
Yes.
Give these bullet points in a writing.
2 minutes.
That the way you have given.
Right. My lord, I'll do one thing. That's I seek your lordship's
You want
indulgence.
to leave.
Here it will be impossible. I know in Itanagar there are difficulties, but I promise that after reaching Guwahati, this is the first thing I will do, and I will ensure it reaches my lord.
You are leaving today.
I would like to leave tomorrow, not today, but getting it typed and giving it to your lordship would be difficult.
Okay.
So in Guwahati, I'll do it. In Guwahati, I'll do it.
Yes.
Tomorrow also you have to be here. No, I won't. I'll run. He's trying to catch me, but I'll run.
Yes, Mr. Das, tomorrow.
That's
Okay, call somebody. We'll pass this order. We'll fix this matter tomorrow for concluding argument of
Yes.
Mr. Das.
When it is my esteemed colleague, Mr. Das, there is one advantage always that though the respondent does not have a further right of reply, but if opportunity arises, I can always put in few words. But with my esteemed colleague, Mr. K.N. Chaudhary, immediately I get the red eyes. I get the red eyes. If he is the petitioner, he does not let me stand up thereafter.
Just a minute, let the private secretary come. By sleep, huh? Keep this file in chamber. Or you can send it to the. Mr. D. Das, learned senior counsel for the petitioner, has concluded his argument. Full stop. Mr. Tiwari, learned senior counsel for the respondent, has also made reply to such argument. full stop. Mr. Das submits that his concluding reply may be heard tomorrow. Full stop. Accordingly, release this matter tomorrow.